Good morning. I hope everybody can hear us. I guess that with a decent academic delay, we seem to be ready to begin. And this is my great honor and privilege to welcome all our distinguished guests today to the University of Silesia in Katowice. I'm really glad that this event is taking place right here at our university, and I'm proud of that not only as a vice rector of the university opening the meeting, but even more as a member of the faculty of law and a speaker at this conference. To me, it's a real proof that the university does its best to fulfill the social mission of such institutions that is much wider than just teaching students and publishing papers. I'd like to extend to you the best greetings and regards from the rector of the university, Professor Ryszard Koziołek. Not being able to be present with us, I know that he really appreciates that we are meeting today to discuss this huge challenge that the future of so-called new judges, neo-judges, is for the Polish democracy and Polish rule of law. I would like also to take this opportunity to thank organizers, the Research Center for Judiciary, and personally Professor Markiewicz, Professor Gajda-Roszczynialska, and their colleagues for putting this all together. We are all, I'm sure, fully aware how much effort and commitment it takes to gather so many distinguished guests. So we really appreciate as the university what you are doing inside our institution and out of it. This is really one of the most important proofs that we are trying to do our civic mission as well as educational and research one. I think that's it for the opening ceremonies, and now let me hand over to Professor Markiewicz to start the first panel, and let's dive into the topic. Thank you.
Bardzo dziękuję panu rektorowi Tomaszowi Pietrzykowskiemu za...
Thank you very much, Mr. Rector Tomasz Pietrzykowski, for opening this expert panel. His role is today of two types: as a rector, but also he will have a speech in the third panel. So again, I'd like to welcome everyone. I'm glad that we have such a prominent guest today. And let me welcome in Katowice our dear friend, Professor Kees Sterk, who is with us representing the University of Maastricht. Ladies and gentlemen, it is no accident that we organize this event this year at the expert panel. And the Codification Commission, and we all are still looking for some optimum solutions to resolve the difficult, complicated issue, meaning the defective appointment of judges in Poland. The fact that they are defective, that's clear. We know it from the decisions of the courts in Strasbourg and Luxembourg. We know it from the decisions of the Polish courts also. The problem applies to over 3,000 judges in Poland. That's 1/3 of all the judges in Poland. And this issue has to be resolved. And while the Polish judiciary is touched by a deep crisis, I'm emphasizing these numbers, these realities in Poland, because even though this panel is organized at a university, this is not only an academic dispute. We want to find a solution to provide all the citizens the right to be judged by a court that is properly appointed and that issues a stable judgment or decision within a certain deadline. At this stage, we're going to present different models, different assumptions. So this is the first part of the two-phase procedure, and I hope that in February we're going to be able to present some drafts that will take into account also the outcome of today's panel. So without further ado, the first panel refers to the status of judges appointed after March 2018 and European standards, and we have really prominent guests today from Poland and from abroad. We have with us Professor Burkhard Hess from the University of Vienna for more than a dozen years. He was a director in the Max Planck Institute for International, European and Regulatory Procedural Law. We have with us Professor Wyrzykowski, an authority and judge of the Constitutional, an ex-judge of the Constitutional Tribunal and expert in multiple commissions that are to bring back the rule of law in Poland, and Professor Marek Safian, president of the Constitutional Court, judge of the Court of Justice of the EU in the years 2009-2024, right now president of the Codification Commission for Civil Law. So without further ado, I'm handing over the floor to you, professors, and the first person to speak is going to be Professor Burkhard Hess. Go ahead, Professor, the floor is yours.
As they start.
Yes.
Good morning, everybody. It's my pleasure joining this important conference, and I would like to address in my speech the right to a court established by the law. All European democracies are based on fundamental values that apply in all member states of the European Union and in all member states of the Council of Europe. In the European Union, Article 2 TEU quotes fundamental values, namely the respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. Respect for the rule of law is the core of the judicial cooperation based on mutual trust between the judiciaries of the member states within the Union. The major gateways where this value is guaranteed to all citizens of the Union is a right to an effective remedy and to a fair trial, enshrined in Article 47 of the Charter of Fundamental Rights. This article of the Charter constitutes, in its second paragraph, the right of every individual to a fair public trial within a reasonable time before an independent and impartial court previously established in accordance with the law. In addition, it's important to highlight Article 19 TEU. This provision states that the member states of the Union are obliged to provide for sufficient legal remedies and effective legal protection in the areas covered by Union law. According to the jurisprudence of the Court of Justice, it follows from these two guarantees that an independent court is of crucial importance for the protection of the rights to an effective legal remedy. Historically, the protection of the right to an effective remedy before a court was already recognized by the Court of Justice in 1986 as a general principle of Union law. As of today, it constitutes a key protection of the individual freedom of all citizens. Consequently, The question arises of what constitutes an independent and impartial court. Since courts as an institution must be independent, it goes without saying that its individual members must also be independent and impartial. Thus, the fundamental guarantee applies to both the court and the individual justices. Since 1950, the European democracies are united by the European Convention of Human Rights that provides for the protection of fundamental freedoms within all contracting states of the Council of Europe. Here, Article 6 of the Convention guarantees that everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. In a long line of jurisprudence, the Strasbourg Court has established an elaborated jurisprudence on the requirements and standards of the right to an independent and impartial tribunal. This jurisprudence originated in the experiences of the totalitarian regimes before and during the Second World War, but were reinforced by the accession of Eastern European countries after the collapse of the Iron Curtain. After 2017, both European courts, the Court of Justice and the Court of Human Rights, were confronted with a changed political situation in Poland and in Hungary, where right-wing governments attempted to capture the judiciaries in order to overcome constitutional and legal systems of the third state power that remain principally unaffected by political change. Justices in these member states, as well as the civil society, showed remarkable personal commitment and courage to resist political pressures caused by undemocratic challenge and disregard. Justices sought the support and the help of both European courts. Both courts took it up. Yet, today's situation creates additional challenges to democratic institutions that have become even more under pressure due to the political developments within France and outside of the European Union, just to look at the US. My presentation addresses the fundamental...
Był wzywany do uzupełnienia braków prywatnego i wniosku o koszty. Moim zdaniem oba są po terminie.
A uzupełniał? Nie uzupełnił.
Nie uzupełnił w ogóle, że nic nie przyszło.
I'm sorry, I didn't understand what was said.
Dobra.
So interpreters note, I think just
The fundamental guarantee of judicial...
Wybitne braki formalne.
To znaczy?
Nie jest podpisane.
So interpreters note, I think someone forgot to turn off their microphone. We apologize for that.
Wyłączenie głosu, ponieważ
Yes, we're asking the person to turn off their microphone to avoid some disruptions. Please turn off your microphone.
Sorry, shall I continue?
Czy mogę kontynuować?
My presentation addresses the fundamental guarantee of judicial independence as developed by the jurisprudence of the two European courts. However, I will not focus on the proposals made by the Commission for the Codification of Common Courts, as I am not sufficiently familiar with the ongoing debate in Poland. Rather, I would like to highlight some essential elements of the jurisprudence on the rule of law and judicial independence with regard to the developments in Poland and in Hungary. Independence and impartiality of the courts. Being a judge is a profession which in itself requires, in addition to great knowledge and integrity, a person with a calibrated sense of morality, fairness, and dignity. The historical background of the independence of judges is based on the guiding principle that the legal institution of independence is conditioned by the fact that the judge should be able to make decisions without any external, especially political influence. This perspective entailed a significant impact on the development of fundamental rights and the creation and development of so-called constitutional states. Judges protect individuals against any violations of their rights by measures taken by the executive or the legislature. Precisely for these reasons, courts constitute a counterweight to the absolute or unlimited power of the elected representatives. Since justices are entrusted with such a fundamental task, it is very important that their decisions and their personal position are independent. Article 6 of the Convention and Article 47 of the Charter guarantee and protect key elements of the right to a fair trial and effective judicial protection. According to the European Court of Justice, certain criteria must be met in order to constitute an independent court, namely, whether the body is established by law, whether it is permanent, whether its jurisdiction is mandatory, whether its proceedings are inter partes, whether it applies the rule of law. In addition, the court points out that a body can be regarded as a court only if it is a permanent nature, for instance, if it does not exercise judicial functions on an occasional basis, and if it is set up by law and not by agreement between the parties. Furthermore, it must operate with full independence. The key to preserving independence are therefore the rules governing the appointment of judges, their term of office, grounds for dismissal, and disciplinary measures. The disciplinary system must not be misused for political control over the content of judicial decisions. These rules must be clearly defined in order to prevent any manipulation that could affect the impartiality of the judiciary or undermine confidence in the judicial system. Similarly, the European Court of Human Rights developed a three-pronged test in order to verify whether the requirements of Article 6 of the Convention on the existence of an independent and impartial tribunal established by law are met. First, the appointment of judgments must be generally free of grave irregularities. Second, all justices deciding the case must be impartial regarding the case at hand. Finally, it is examined whether such violations have been properly considered and remedied before the domestic courts. External and internal independence. According to the jurisprudence of both courts, the independence of courts comprises two key dimensions, external and internal. The external dimension involves the protection of the court from external influences and political pressure, which could undermine the impartiality of judicial decisions and thus threaten the independent judgment of its member in relation to the proceedings before them. This includes safeguards against the dismissal of judges without just cause, the lowering of the retirement age, appointment rules that exclude political control, and a guarantee against removal from office in order to dispel any reasonable doubts that individuals may have as to the impartiality of the judiciary with respect to external factors. On the other hand, the internal dimension of independence relates to impartiality, the guarantee of equal treatment of the parties within the proceedings, and of objectivity in the decision-making process. Courts must have no interest in the outcome of a case other than to apply the law fairly and impartially. To this end, the rules of procedure, the composition of the courts and their work must be such as to remove any reasonable doubt in the minds of the individuals as to the neutrality of the courts. These principles ensure public confidence in the judicial system. Internal independence refers to impartiality and ensures that all those involved in the proceeding receive equal treatment. It implies objectivity and the absence of any interest in the outcome of the proceedings other than the strict application of the law. In addition, it should be noted that disciplinary measures against judges, such as the transfer of judges to different positions without their consent, deeply jeopardize judicial independence. In case C-487/19, the Court of Justice of the Union emphasized that every disciplinary system must include clear procedures and guarantees to prevent the possibility of any political influence on the court system. Rules governing the conduct of judges, disciplinary offenses, and penalties must be defined in such a way as to exclude any abuse. The transfer of judges without their consents, such as transfers between judicial divisions, may violate the principles of independence and, more precisely, of removability of judges. Such transfers may have a significant impact on their professional careers and must, therefore, be carried out only for legitimate reasons, such as optimizing the allocation of judicial resources while fully ensuring all procedural guarantees. The limitation of such measures is essential to maintain public confidence in the judicial system and to protect the independence of the judiciary from external influences. Now I would look for a moment to the procedural frameworks implementing the protection of judicial independence. It is interesting to see how the core values of judicial independence were implemented in the procedural frameworks of both courts. Both were flooded by a multitude of preliminary references and by multiple individual complaints. Yet, both institutions were able to channel these cases into more general remedies. Within the Court of Justice of the European Union, infringement actions initiated by the European Commission played a crucial role. They gave the Court of Justice an opportunity to decide in its most prominent composition, the Grand Chamber. In several infringement proceedings, the court had to decide on the lacking legality of the legislation enacted by the Polish government aimed at transforming the judiciary. It also permitted the Commission to challenge directly judgments of the transformed Constitutional Court infringing EU law, especially Article 19, first paragraph of the treaty. These proceedings are still ongoing. The European Court of Human Rights used the pilot judgment procedure to streamline 492 cases concerning the judicial reforms in Poland initiated in 2017. In Wałęsa versus Poland, the court held that the legal changes in Poland amounted to a serious systemic situation entailing repeated violations of Article 6 of the Convention, of fundamental principles of the rule of law, the separation of powers, and judicial independence. These procedures permit to shift from the breach of the fundamental guarantees and to focus on possible measures to end the ongoing breaches. Both European institutions provided for guidance on how to comply with the fundamental principles and to remedy the serious breaches of the rule of law. However, there is a need for a political will to comply with the requirements of the European public order that is based on judicial independence and the rule of law. The Polish election in fall 2023 opened the door to overcome the present stalemate despite the persistent resistance of some state organs. Now the time has come to remedy the faulty judicial appointments that took place with the involvement of the politicized Judicial Council during the last 5 and 6 years. I conclude. The core principle of the legal order of the European Union is the primacy of union law over national legislation, including the constitutional provisions of member states. According to the jurisprudence of the Court of Justice, no national norm, not even a constitutional one, can take precedence over EU law or reduce its effectiveness. This principle is essential to preserve the unity of the legal system of the Union and the equal treatment of the member states in accordance with the legal framework. National courts must also ensure that Union law is interpreted in accordance with the case law of the Court of Justice of the Union, which has exclusive jurisdiction for the final interpretation of Union law. The independence of the judiciary plays a crucial role in safeguarding the core values of the Union and the Council of Europe. Article 19 TEU and Article 47 of the Charter, as well as Article 6 of the European Convention of Human Rights, require member states to guarantee the independence and impartiality of the judicial systems. These principles constitute the foundation of the European legal order and ensure the protection of individual rights. Accordingly, states have an obligation to refrain from enacting laws that would jeopardize these principles, including measures that could undermine the independence of the judiciary or weaken citizens' confidence in the judicial system. The Court of Justice of the Union has emphasized that the national identity of the member states, as defined and protected in Article 4, second paragraph, TEO, cannot be used as a justification for derogating from these fundamental obligations. It is important to understand that independent judges are the key link between citizens and their trust, not only in the legal system, but also in the entire state order. Judges, with their integrity, moral values, and professional knowledge, often provide the last refuge to individuals in seemingly hopeless situations. It is precisely of this central role that the judiciary is often the first target of those who seek to weaken the state and consolidate their own power by disrupting existing systems. We must therefore remember G. Santayana's famous saying, "Those who cannot remember the past are condemned to repeat it." The lessons of history remind us of the devastating consequences of destroying a country's legal system. It is therefore essential to preserve and to restore the independence of the judiciary as a pillar of democracy and the protection of human rights in order to avoid repeating the mistakes of the past. Thank you very much for your attention.
Important value introduction speech. Okay, Mr. Professor, thank you for your important and value introduction speech. Proszę Państwa, tak jeszcze...
Dear ladies and gentlemen, the drafts are not presented yet. It's in the nearby future. These speeches are aimed at leading to the fact that they're optimal. Dear ladies and gentlemen, I hope that the next factor to the optimization of this factor is the speech of Mr. Professor Wierzchołkowski. And his speech will be about the status of the judges appointed after 2018 in the context of the case law of the European Court of Human Rights. Professor, the floor is yours. Thank you so much. Thank you so much for the invitation. And I am honored, but I am a little bit ashamed because today we have Professor Mark Savian, who is the judge of the Court of Justice of the European Union, who will be shortly discussing the problems from his own experience as a judge. Well, honestly, here, in my place, there should be a Polish judge of the European Court of Human Rights in Strasbourg, but because I was invited and I am present, please let me widen the problem and show you what was an important element. So the ending of Professor Hess, the framework and the context. And we have the following situation in which the ceterum censeo, we should not forget, just not to remind, we shouldn't forget the state in which we are. We are used to the fact that we evaluate the assessment of the destruction of the constitutional state from the perspective what has been done and from the perspective in which point we are right now. But the fact that there was destroyed the legal order of the state, it doesn't mean that we don't have the reference points for the actions that are to restore the state of constitution. And I think that if what has been said many times, the Constitutional Tribunal made a double suicide, institutional and moral ones. So the non-existent Constitutional Tribunal was in its function replaced by Strasbourg and Luxembourg. So here I'll be just shortly refer, what I mean by them, which courts I refer to. So it means that the case law of these two courts creates the base, the legal base, and the axiological base for the actions aimed at the fulfillment of the process of restoring the rules of law. And what's interesting Maybe not all of us remember, but the ones who are not happy with the grace of being born late, we remember as 20 years ago, it was mentioned that the membership in the European Union of the Middle Europe, we can see the Europe of two velocities. I have the impression, referring to the previous observation, that in the case law of the European courts, we had two velocities. Because first, its case law started the Luxembourg court, and only 5 years ago, the process of case law by the Strasbourg court started. Probably such situation, I don't know exactly the metabolism of Strasbourg or Luxembourg, but I have the impression that a lot depends on who is the judge and how they understand the role as a judge in the mechanism of adjudication. And today we should be talking about judges and what is characteristic for these two different courts and what is important for the consequences of the judgments of Strasbourg and Luxembourg is the initiative of examining the cases or the complaint to Strasbourg, and the essence, the prejudicial questions to Luxembourg. And it has specific consequences in the scope of responding to the problems that are included in these questions or in these complaints. And of course, Strasbourg concentrates on the freedoms of individuals, and Strasbourg responds to the posed questions by the complaint, what is consistent with the convention and what infringes the convention. Luxembourg, as you know, when it responds prejudicial questions, it gives an answer to how the court should behave, the domestic court, taking into account the standards of the EU law. So we have clarity when it comes to the case law of Strasbourg about what you cannot do, what is prohibited, what is breaking of the European Convention. And as you know, breaking of the European Convention is breaking of the Polish Constitution due to reasons that don't need explanation. And what is more, the evolution of both courts. Here I have the impression that it led to the fact that the judges of international courts, they went away from the basic concept of adjudication of individual case for the benefit of perception of the context and the context in which the individual case was created and presented to the judge. This systemic view was decisive for the fundamental judges of Strasbourg and Luxembourg.
And in the decisions issued by the court in Strasbourg as the point of reference, meaning the principles concerning the way in which judges are appointed and the consequences of violating these rules, including in the Astralson case. I'm not going to remind it in detail right now, as it is not necessary, but what I'd like to point out is what the professor said, that the judges' independence is of crucial importance, but as a consequence of 10 Polish cases which had been resolved until the Wałęsa case, well, judges' independence
Pojęcie sądu
combines the rule of law and the understanding of a convention as a guarantee for the correctness of that process. And there are two basic judgments made by Strasbourg. That's Grzęda versus Poland and Wałęsa versus Poland, and several other cases that I'm going to just indicate that refer to the status of judges, but not the mechanism in which judges were appointed. And what follows from the Grzęda case, and what is of significant importance for legislative work, is emphasizing the specific character of the status of judges from the point of view of their independence and from the point of view of the bond between the judge and the state, meaning as a structure, not as a personal substrate of a given minister or public prosecutor. Second, the law is a certain context, and the status of judges regulated by the law must be evaluated using a broader context, which was done by the courts both in Luxembourg and, in particular, in Strasbourg. Showing the conditions that have to be met in order to consider that the status of a given judge is consistent with the convention standards. And third, what's important is indicating that there are certain solutions which are apparently just technical, neutral, of no significance for the status of judges. But if we look more deeply, it's going to turn out that this apparently technical element, this apparently neutral element, actually has impact on understanding the status of judges. And now, if we look at the case of Grzęda versus Poland and Wałęsa versus Poland, the starting point is KRS Council, the wrong appointments, in whatever way we assess them. In other words, any legal regulations that are to refer to the status of the judges appointed after 2018, they have been executed by the regulations concerning the National Judiciary Council. But what's important in Strasbourg's statement is emphasizing the level of deformation of the first element of the mechanism of appointing judges and of the procedure itself. In the Grzęda case, Strasbourg said that the Chamber of Public Affairs, the judges of that chamber are not judges within the understanding, the meaning of the convention and within the meaning of the Polish constitution. But explicitly, this refers to the judges who make statements as the Chamber of Extraordinary Control and Public Affairs. But it is clear from the Grzęda case that doubts which refer to those persons within the Supreme Court refer to all the Polish judges appointed after 2018.
m, który zawarty jest w dwóch kwestiach.
But here we should address the issue of absence of statements from Strasbourg from the point of view of our needs, especially the peace of conscience and the peace of mind of the persons who prepare changes to Polish law. Meaning the question that was not answered by Strasbourg. The first question was whether every case of participation of a neo-judge within the panel of any court is tantamount to violation of the rights of participants in the proceedings. And the second question was, what are the consequences of participation of a wrongly appointed judge within the panel?
Pozostawania orzeczenia w obrocie prawnym.
For the judgment or decision to remain within the law. There is no unequivocal response. That there is no response that would provide a solid foundation for legislation and drafts, but this doesn't mean that from the systemic point of view of the principles of judges' independence, that we cannot draw conclusions for the process of recovering the rule of law. And why is that?
W przypadku
Well, that's because what was created in Strasbourg and in Luxembourg was a specification of standards. This means the standard means that we have the possibility and we know what the state of affairs is, and we know what the legal qualification is.
mamy orzeczenia.
But what is more important is that we have decisions that are to be enforced. And if we refer to international law in the rule of law, that's Article 9 of the Constitution, this means that the Republic of Poland
które uniemożliwiają czy
may
utrudniają
not invoke internal obstacles that make it impossible or difficult to enforce the judgments of international courts. Because the enforcement of court decisions, this is the framework within which we have to operate. And as we know from the discussion which has to be taking place simultaneously, we're dealing with some directives, suggestions, recommendations, not from international judicial bodies, but from the Venice Commission, for example.
taki problem.
So I'm not going to address that in detail right now, but certainly this issue is going to come up in the future too. And with 2 minutes left for me, I want to indicate how what's going to be done is going to be evaluated in the decisions of the Court of Justice and of the Court of Human Rights, because there's going to be some new regulation, new hearings, prejudicial inquiries.
To się okaże, bo już wiemy, że
And are they going to be interpreted as inquiries asked by courts? Well, the chamber that we mentioned is not a court within the meaning of European law, and so there's going to be individual complaints or inquiries, and we do not know how both courts are going to respond to the Polish regulation. But when we read the decisions, is the systemic approach of the Strasbourg and Luxembourg courts. This systemic approach is also decisive from the point of view of what is the new element of transitional justice. This new element, this novelty, does not allow to copy the findings from the past, and this is an issue which in Poland the legislators take some discretion to determine, or maybe not discretion, but a more free regulation. And the last issue now, what, as Professor Hess mentioned, there are over 500 cases from Poland that are in Strasbourg. We have the pilot judgment Wałęsa v. Poland, and so we have the obligation for the Polish authorities to act, to operate. Poland was asked to develop suitable measures, and in December, these measures were to be implemented by December this year, so by the end of this year. But now we have one more year. This deadline has been postponed and so we have one more year to fulfill the obligation to present measures to bring back independence of the Polish Council and to regulate the status of all the judges appointed in the defective procedure. And that this means that the plan that has been assumed for legislative work can be actually fulfilled within the deadline set by the Strasbourg body. Thank you very much.
Thank you. Thank you, Professor. The professor emphasized the framework that are presented, that give us certain borders, and within which we have to fit in, so that in the further case law of both courts, not to determine an infringement of the law. And about the framework, about the borders, where we have to remedy the rule of law, also the co-host talked about it, the Professor Marek Safian. So he's a co-host because for a few weeks, even for a month, he's the honoris causa doctor of University of Silesia. And his last words of his lecture, the professor talked about the borders which the law poses to restore the rule of law. But the professor emphasized that it's about the law written by the capital L, and referring to his lecture of honoris causa doctor, professor of our university. I'm handing the floor to ask and to request for a viewpoint in the context of the Court of Luxembourg. Professor, the floor is yours. We have some problems with the connection. Professor, can you please unmute yourself? Can you please click the icon? I think, can you hear me now? Now we can hear you very well. Thank you very much. I'm sorry about this technical these technical problems. Thank you very much for the invitation. I also feel honored, double honored, that you mentioned for this important and moving event for me, and that again I can show you my thoughts about the case law of the tribunal. Many things have been said so far. Are there any technical problems? No. Many things have been said, so sorry if I will be repeating myself somehow. Can you hear me? Excuse me? Can you hear me? Everything is okay. Everything is fine. I would like to start from my thoughts maybe this is not very typical for the assessment of the case law from the viewpoint of the status of judges appointed after March 2018 in the Republic of Poland. Because I would like to draw your attention, and this is of course my subjective choice, I would like to draw your attention to the case law, which are the new foundation which create the framework for the development of the whole jurisprudence. The case law of the court in Luxembourg. And the first remark is the first part refers to 4 important cases that are important to understand how the whole line of case law can develop of the court of law, referring to the independence of courts. And definitely here it will be no wonder if I say that the starting point was the famous case, and this was about the Association of Portuguese Judges, a judgment that was the base of further reasoning in that case, or in the cases connected with the independence of judges, and that was the judgment that it was the interpretation of Article 19, and it was very crucial interpretation, because this was the name, so this was about the Association of Portuguese Judges, and according to me, 2 things are a very important element of this judgment. First of all, for the first time, the Court of Law determined definitely that we face specific common for all courts of the European Union requirements regarding to national judiciary dealing with European cases. Here there is definite statement that imposes specific common standards for cases regarding the functioning of the justice system in the European Union. So the Article 19 that mentions that the justice is performed by the tribunal and international courts, and it was found to be the basis of direct application. And this is second important element for all of those who are dealing with the use of the basic fundamental charter of human rights, that the court goes away from the requirements that were formulated on the basis of the Article 51 of the basic fundamental human rights to find the connection of the standard resulting from the Charter and the European Union law, a specific mechanism of the European Union law, and here it says that it's about a different relation that it's mentioned in Article 51. So it allowed to look from a wider perspective at the requirements for the European Union judiciary, here in the context both of the national courts and the tribunals. And here it was also the response to the Polish government's arguments that we very often hear, all the time we can hear that argument, of course not from the government, but it can be heard many times also in doctrine or in public discussions, that the tribunal works outside of its competences, and this is an institution that goes into restricted area, just interferes into the national jurisdiction. So dealing with them, for example, of the appointment of judges, the status of judges, the instances of, and the regulations that regulate the national courts are not the competencies of the justice tribunals. And here it's a very important matter to say, no, it's not true because the whole case about functioning of the national courts in the scope that this function regards, here, practically speaking, all the national courts, it's connected directly with the European Union law, and in such a way that all the national jurisdictions must provide specific requirements regarding the independence and impartiality of the judges. And this is an important condition for the whole functioning of the justice system. And it allowed to further to go to assess the solutions which are used by member states. The second judgment that I think it's really important and necessary to recall, this is the judgment from March 2020 about Simpson case, which directly introduced something which we use today also in our national jurisdiction. This is the test of independence of judicial independence. Here, it was clearly introduced by Simpson judgment, but it didn't refer to the Polish case, but it referred to another type, and it was the case of a judge, of appointment of a judge to the Tribunal of Public Functions, and in that case, it was the thesis presented for that the defect of appointment of a judge is as important as if it's negatively tested, according to the public opinion. So, shortly speaking, when the defect of appointment of a judge is so important that in the perception of an outsider and outside audience who looks at the justice system, the position of a judge raises serious doubts, and it can be the basis for the lack of trust for the issued judgments. And this is, as you know, this is present in the next following cases. It's present in all the cases that referred to the Polish judges. And the third case that, according to me, is very often skipped, it's forgotten when we discuss the judgments of the Court of Justice. This is about the Great Chamber. This is about the Republika case. This is about Malta. What's interesting, and what new things does this case bring, and how does it create the start point to thinking about the reform necessary to restore the standards of the rule of law? The case Republika, for the first time, introduces the rule that says that there is a specific reference point to which we always have to refer in the analysis when we look at the functioning of the mechanisms from which judicial independence depends, and that moment or that reference point is the level of protection of the rule of law in the moment when the member state accesses the European Union. And that level that is in a given state must be minimally observed in a minimum way. And this is the level that is, here we have Copenhagen standards. This is the minimum that each member state must fulfill to join the European Union. Of course, it includes the requirements about the rule of law and judicial independence. And here it was the case that a new mechanism was introduced in Malta, and it was inconsistent with the requirements that were necessary in many countries as the condition how to appoint an independent judge. And the Court of Justice, after long debate, reached the conclusion that if the mechanisms which were introduced in Malta are the essence, the basic step forward, they must be treated as the one real fulfilling the rule of protection of judicial independence according to the direction that was in Article 2 of the Treaty on Function of the European Union, because the level from the moment of access was crossed. And this is also an important element. When we think, or how we will be also, what we will be also taking into account when we create a new shape of the mechanism. And then there is the fourth case that seems to be really important and very basic or even fundamental for the debates, how the restoring of the rule of law should look like. And this is a case that was made in the full composition of the Court of Justice, which is a really rare case. This is an exceptional case due to the importance of this judgment. It was about the mechanism of conditionality. It was from the 16th February 2020. And not to go into details, it clearly defines that we are facing the value, the judicial independence and the rule of law that includes the identity of the European Union. This is the first issue that I want to draw your attention to. And the second one, that none of the elements, and also Professor Wyrzykowski and Professor Hess mentioned it, that none of the elements that would refer to the constitutional identity of the member state, referring to in such a way that to question the common understanding of the values at the EU level, that they cannot be taken into account, they cannot create arguments which the member states should use in the situation when it introduces certain mechanisms for the independence of judicial independence.
This is very important because again and again we hear the argument in the debate in Poland that the Polish understanding of judicial independence or of the law of law is different from the standards developed within the judicial decisions of the Court of Justice of the EU. It's important to remember these decisions also in order to realize that they constituted a mechanism of defense within the legal system of the EU as a whole. And I'm going to say something that might seem obvious, but one that has to be said, that whatever happens within a member state in terms of rule of law in Poland, Hungary, or any other member state constitutes a challenge that may not be tolerated within the European order. We cannot rule out and create an enclave for one member state only, because whatever happens at the state of a member state with regard to the rule of law also translates to the entire European Union, and the EU has to defend itself in invoking its common mechanisms and principles. And now, as for the characteristics of the decisions concerning the judges' status, I'm going to point out what has been mentioned today on many occasions, mainly that the approach of the Court of Justice of the European Union was based on the contextual analysis, which took into account all of the mechanisms and conditions of evaluation of judges' independence, status of the judges, or of the nomination status of the judges. These are not elements taken out of the context and evaluated separately. No, each of them is always included within a certain context of a given member state and conditions within which the given country operates. And only then will we be able to understand the depth of analysis presented by the Court of Justice, and only then will we be able to defend against the accusation formulated on many occasions against the Court of Justice that it assesses in different ways the mechanisms that are similar in the respective states, while it forgets that these mechanisms are different because of the context. And this was what took place in the case of Poland. A typical example for this kind of reasoning was the case from the 19th of November 2019, concerning the National Judiciary Council, concerning the appointment of recommendations to the disciplinary chamber. I'm not going to remind you all the factual information, but this is the basis for reasoning that we will see in many other decisions, meaning the statement that the National Justice Board raises fundamental doubts in terms of the standards of Article 19, i.e. the mechanism ensuring judges' independence, because it is a body which is appointed in many ways in violation with the requirements of the Constitution and raising significant doubts with regard to independence or political impartiality of the National Justice Board, which may provide grounds for formulating the thesis that this is a body that only follows the instructions from the executive authorities, which has a political mission without objectivity. This decision is very crucial, and the issue of defectiveness of appointment of judges, the defective mechanisms, it also appears clearly in the judgment from July 2021. That judgment referred to a disciplinary regime with regard to judges. So there are two elements here in the decision that is very important for understanding the tendencies in judicial decisions of the Court of Justice of the European Union. So naturally, the context of appointment of judges to the disciplinary chamber, the context includes the competences of the Minister of Justice, public prosecutor, who had all the instruments in their hand to appoint judges to the disciplinary chambers, and the character of the defectiveness identified by the Court of Justice, which defect was structural in nature. So what was against the background of what was described within the Polish context of appointment of judges by the National Justice Board in violation of Constitution and other legal standards, including naturally Article 19 of the EU, the Tribunal seems to be saying that this is a structural crisis, in fact, which is impossible to resolve through a single lawmaking maneuver, but instead one that requires deep transformation of all the entire system, because only then will the result be positive. The assessment concerning the constant and the structural crisis, in fact, can be found in the decision issued recently with regard to the Chamber of Extraordinary Control and Public Affairs of the Supreme Court, meaning there's a decision from the 21st of December 2023, where the Tribunal again analyzed the defectiveness of the mechanisms in which judges are appointed in Poland, they also analyze a number of other additional elements which must be taken into account and which show that in the specific case of the Chamber of Extraordinary Control, the panel is so deformed, which panel must not be interpreted as a premise for considering its members to be judges within the understanding of EU standards. Let's remember that in this case, the evaluations are similar between the EU Court of Justice This is a specific analysis of the arguments and of the standards transferred in Strasbourg, that's Dolińska-Ficek. That was an analysis of a number of elements which resulted in invalidation by the Chief Administrative Court of the letter of recommendation of judges to the Supreme Court, that was 19 judges. And then the decision was made to suspend the procedure of appointing judges, which procedure was not respected by the President of the Republic of Poland. And the accumulation of many factors concerning the effectiveness has caused the Court of Justice to say clearly that the judges within this chamber are not judges within the meaning of European law. And so that's why the judicial inquiry made by these judges is not admissible at all. What should also be important is the perception by the Strasbourg court that this is withdrawal or departure from the previous judgment in the case of Getin Noble Bank, where the court decided that with regards to prejudicial inquiries which come from the jurisdiction that functions within a given member state, this is not the status of judges is not examined basically, but the court took one step further and said that when there is a developed standard for international European judicial decisions, meaning Strasbourg decisions, this position may be departed from, and one may consider then that this is an accumulation of factors which result in such a far-fetching evaluation, meaning this is not a judge within the understanding of EU law. And the Court of Justice never adopted an automatic attitude concerning the facts until the case of Simpson, of any procedural defects for appointment of judges and invalidity of such appointment. And each time the Court of Justice required a test to be performed within the domestic system, unless there is a significant defect, like in the case of the Chamber of Extraordinary Control or previously disciplinary chamber, where the Court of Justice said clearly and directly they are not judges who could effectively rule in the cases concerning the EU law. And well, I know that I am running out of time quite soon, but I think one more thing that I would like to mention that is a typical feature for the Court of Justice, meaning a typical two-stage test, which is used in the situation where, generally speaking, the court has doubts regarding the independence of a domestic court or of a judge appointed within a procedure that might seem defective or incorrect. It's a test that was first applied in the case of Ministry of Justice and Quality. That's a case from 2018 in Ireland, an Irish-Polish case. It was a European arrest warrant issued by the Polish court, and the doubts regarding the enforcement of that warrant from the point of view of evaluation of a Polish judge and the Luxembourg court stated unequivocally that if there are premises that point to a structural crisis, the judge may not automatically cause the enforcement of the European arrest warrant. This automatism is normally within such a warrant, but before that, the judge has to have that test performed, meaning through the inquiries, additional explanations, the situation should be examined in order to unequivocally determine the doubts and the nature of the doubts, the nature of the potential defect that may result in the lack of trust in this judge. I do not want to go much further, but I think that at the very end I should make some general remarks. So despite the fact that the Strasbourg and Luxembourg decisions are not identical naturally, but they are similar in many crucial elements that are not identical. If we look at the Simpson and Astralson cases, they are not identical, but they are very, very similar. And I think that the case that was resolved recently in December 2023, it is proof that these positions are becoming more and more similar. And what we should remember is that what we are dealing with in Poland should be characterized as a special kind of situation of a structural crisis, which requires a different approach than just standard changes that might require individual decisions to be made by the lawmaker. And the third issue is that the decisions by the Court of Justice are all the more precise and specific and provide grounds for correct interpretation, the better and the more detailed the prejudicial inquiries are. And I think that Polish courts demonstrated very well in the cases of judges' independence how significant the dialogue with the courts can be and how one can effectively apply European instruments in order to defend common values. And as for a direct implementation of those judicial decisions, I believe that although sometimes we might have trouble with determining the consequences of a given decision, let's remember that this is the nature of European decisions in the cases resulting from prejudicial inquiries. The weight of final determination is always lying on the domestic court, and this is the essence. The interpretation is common and binding, and the interpretation makes the domestic judge and the domestic bodies not to take into account the mechanisms of the domestic law, which are violating the established interpretation of the Court of Justice. Certainly, there are grounds for, like Professor Wyrzykowski said, and I agree with him, there are grounds for looking for the correct point of reference in the interpretations adopted by the Luxembourg court. They are sufficiently clear and specify certain obligations for all the lawmaking bodies of a given state, which have to be taken into account nowadays. This applies to the National Judiciary Board or the two chambers of the Supreme Court, because, well, today we're wondering about how the Chamber of Extraordinary Control and Public Affairs should be issued, while such an inquiry should not be asked at all, taking into account the decision from 2023. So, although some believe that there is a deficit in Luxembourg decisions, and even though some decisions lack unequivocal answers, if we look at it more deeply from the point of view of the broader context, then I believe the responses that will be provided to recover the rule of law.
Thank you, Professor, for your really interesting presentation. Dear ladies and gentlemen, to sum up this panel, here we are moving into two dimensions. The first one, what results from the current jurisprudence to the reforms conducted so far, and there is no doubt that we can determine that till 2018, these appointments were with huge infringement of the systemic law, and there are some judgments that directly say that the courts consisting of neo-judges are not the courts within the understanding of the European law. We know, and what Professor Safian emphasized, that we are in an extraordinary situation, and it is an unprecedented situation when it comes to challenges that are ahead of Poland to restore the rule of law. We have a lot of answers, but we still don't have answers. We don't have single responses because they cannot be said right now. I'm just talking what is ahead of us. So, how to proceed with such persons whose appointment is defective, and what to do with the judgments which were rendered by them and which are being rendered all the time. So the situation is ongoing with one on and the second Court of Justice. Currently, it's suspended when it comes to Strasbourg Court of Justice, the court, due to the issuance of pilot judgment, and waiting what Poland will do when it comes to adhering to this judgment from the 23rd November last year. Professor has talked about 500 of cases. Now, I think it's about 700 cases that were filed to the Court of Justice. Of course, not all the important issues that were referring to the Polish judgment, but also there were the cases connected with assessors. And what's important is the fact that there is dialogue ongoing with the Court of Justice from Luxembourg at the beginning of January 7th or 8th. So 3 days, 3 Polish cases that are about the neo-judges, the problem of the people who are performing the functions in the Supreme Court, who are the judges. And I think within few coming months, we will be smarter and we will have new judgments. Thank you so much. Thank you, gentlemen. Thank you, Professor, for your valuable presentations. And I think they are a great introduction to the next panel, but it will start after a short coffee break, I think 10 minutes. I think it's enough time to drink coffee or tea. Thank you so much. See you in
Państwo, witamy na drugiej
Dear
części.
ladies and gentlemen, welcome you to the second part of the expert panel. The speech will be started by the President of the Codification Commission, Professor Krystian Markiewicz, and here we will have his introductory lecture. Then it will be Professor Marcin Balasik, and he will tell about the possible models of restoring the court appointed by the law in the Polish legal system. And our third speaker will be Jarosław Matras, judge of the Supreme Court Criminal Chamber, and he will talk about the stability of the case laws issued by the judges that were appointed after 2018. Professor, the floor is yours. Dear ladies and gentlemen, thank you once again. The introduction, few remarks about what we are facing with, what the Codification Commission came across, what were the assumptions of its works. Dear ladies and gentlemen, the Codification Commission was set up in April 2024 and immediately faced the task that it had set itself, namely to implement with the Minister of Justice, works together with the Minister of Justice, but it's not the part of the Ministry of Justice. And this task was about the performance, the implementation of the judgment of the case mentioned many times today, Wałęsa versus Poland. Poland was obliged in this pilot judgment within a year from 23rd November 2023, and it's to solve systemic problems that were presented against the European Court of Human Rights. And as a reminder, it dealt with several issues. First of all, it was about the actions of the National Council of Judiciary. And this action, as you know, is faulty, defective. And also, it was about the systemic problem, about the appointments of judges, about the functioning, the Chamber of Extraordinary Control and Public Matters, and the twin chamber of professional responsibility and as its twin body, and also the issue of the extraordinary complaints. And recently, Poland obtained the prolongation to deal with this problem, but of course, the time is always on the run. The Ministry of Justice prepared a draft law on the National Council of Judiciary, which was supposed to which had its history, few changes, also amendments on behalf of the Ministry of Justice as a result of the Venice Commission opinion. Then the act was it was directed, but it was adopted, but it was directed to the Constitutional Tribunal, and the case hasn't been examined so far. The draft, the act, which is not yet signed by the president, and this draft fulfills the requirements about the constitution when it comes to the component and the basic European standards. Of course, the problem reminded about the effects of the activity. Here, I'll be shortly speaking about the new National Council of Judiciary, so with the participation of the current Council of Judiciary, so after March 2018, so about the process of appointment of about 3,000 judges. This process is still ongoing. We have new resolutions of the National Council of Judiciary. We have new appointments to judicial positions. Even it was last week, and it was determined during the last panel that both from the case law from the courts of Luxembourg and Strasbourg, we find in the case law that we have a systemic problem. Again, I will be just shortly speaking of new judges, that it's not a problem of special groups, subgroups, or individual groups. that were appointed after 2018, that it's not just the problem of the judges of the Supreme Court, but it's the problem of all the appointments that were made after March 2018. And as the Commission, we also knew that it's not the secondary problem, but it was also the problem that resulted from the systemic and gross infringement of the Polish constitution and European standards. And these infringements that weren't, still are done, if to a far greater degree than the ones that which occurred in Iceland, which were the basis, the previously mentioned judgment in Astradson case. And let's remind by one sentence that the solution of that problem when it comes to Iceland took place through adopting a new act and once again conducted nomination procedures, competition procedures. Dear ladies and gentlemen, it was also time on, or maybe still is time, such time when several hundred of Polish cases were referred to the European Court of Human Rights. Well, the cases, of course, referring to neo-judges, it was the time when the Polish courts began to overrule rulings issued by neo-judges. This was the time when there are few suspended cases about the faulty appointments. And here it is about filing applications to conduct tests and about exclusion of the judges, which hinders the cases in Poland. And in Poland, there is this discussion how to deal with this problem has been ongoing for a long time. But when a special commission, whose I am head of, was started, there was one project presented by the expert who worked with the Polish Association of Judges Justitia. There were, of course, other opinions expressed. They were about the use of the vetting procedure against the faulty appointed judges. That is, in the meantime, a few months ago, the Ministry of Justice presented its concept of dividing judges into different color groups. They were presented in some slides. There was supposed to be another ministry condition that was conducted with a regret of judges, active judges who were supposed to make a statement about the reasons how they want to come back to their earlier post. And there was also the evaluation of judges' behavior in terms of disciplinary offenses. The ministry withdrew from the project. The codification commission of the courts and prosecutors' offices, that the only accepted solution is the one that would be based on systemic assumption that the problem lies in the appointment procedure. And it's therefore surplus to assess other issues, such as those relating to the appointment process itself, because it's directly connected to the requirement of a court established by law. The issue of possible disciplinary liability of judges relating to individual conduct was left outside the regulation of the draft. Of course, it didn't eliminate the responsibility, but it was not what the bill was all about. The Commission was fully aware of the violation of European standards regarding the court established by law. We have seen an evolution in the jurisprudence of the European courts. I will just remind what the Professor Safian reminded, that the Strasbourg court responded preliminary to prejudicial question, but from over the time, it has been recognized as regards judges of the Supreme Court that they are not the court entitled to ask a preliminary question. And something very unusual, the Court of Justice has departed from the presumption that the National Court asking the preliminary question meets these requirements regardless of the specific composition of judges. And at the beginning, this departure from the presumption regarded people from the supreme control. But in November, recently, like a month ago only, the Court of Justice, this departure from the presumption also referred to the judges or the people in the civil chamber of the Supreme Court. It should be emphasized that the European Court of Human Rights in the case of Wałęsa versus Poland drew attention to the systemic problem of all judicial appointments in Poland due to the operation of the National Council of Judiciary in its current form. But also Professor Wyrzykowski mentioned that fact. The Codification Commission was aware that the current international legal standards, they just confirm the breaking of the rule, but they don't address how to restore the rule of law in a situation as such as the one in recent years in Poland, where the literal standard resulting from Article 47, Article 6 of the European Convention on Human Rights, or Article 47 of the Charter of Fundamental Rights didn't change, but it has factually been changed both at a statutory level and in constitutional practice of certain state bodies, in particular the Constitutional Tribunal or the National Council of Judiciary. As a consequence, to simply rely on a literal understanding of international legal standards concerning, in particular, the right to a court in relation to a defectively appointed court judges would lead to the perpetuation of solutions that are directly contrary to the rule of law, the rules of the right to a court. So the issue before the Commission was how to restore the rule of law, and they remain in line with the international standard, with the Polish constitution. Importantly, we were aware that the effective, here I would like to draw your attention to the effective obligation to restore the rule of law is not possible on the basis of the standards in the current form alone, but we require here new ideas, the development of the standards, of course, with respecting the cultural legacy of Poland and Europe. And dear ladies and gentlemen, what's the status of persons appointed with the participation of the National Judicial Council elected after 2018 as persons who have not been successfully appointed to the office of judge at all? So people who just come from the outside, from the judicial post, or it's maybe not about it's about the promotion to the judge to another court. So here are the two groups, which probably Professor Walasik will be talking more about them. Dear ladies and gentlemen, here the starting point in our discussions, taking into account the Constitution regulation, was the adoption that the National Council of Judiciary, the one that is functioning currently, is not the body referred to in the Polish constitution. And as a result of the inconsistent formation of the current National Council of Judiciary with the constitution, it's impossible to say that this constitutional requirement for the participation of judicial self-government bodies in the appointment of judges was present. And due to the fact how this Council of Judiciary was shaped and its composition, what is its meaning? Well, it has a crucial meaning, because deciding if, and it was also confirmed by judgments of the Polish courts, it leads to the conclusion that there is the lack of one of two elements necessary to talk about the effective appointment of a person to the position of a judge. And the application for the appointment of judge within an Article 179 of the Constitution must be formulated by the body which is mentioned in the Constitution. So the body which is created according to the Article 186 and 187 of the Constitution. The current Council of Judiciary is not a body such a body. And this is not just the whim of the Codification Commission, but it's precisely stated in many judgments of the Supreme Court and the Supreme Administrative Court. And the Codification Commission doesn't take into account that they will not take into account these judgments. So, once again, I would like to emphasize that the motion of the National Council of Judiciary is a sine qua condition for the appointment of a judge, and there is no such application. So there is no effective appointment of a person to the position of a judge. This is not just a secondary for defectiveness in the process of nomination, but here we are just following the European course, but that this is just a gross and systemic violation of the law in case of judicial appointments. And as the Supreme Court noted in one of its decisions, and it's 3 CZP 25/19, and then it was about court in Luxembourg. It's only after its Council of Judiciary application is submitted to the President of the Republic. That is his competence to appoint the person covered. The application of the office of judge arises. So the procedure that infringes this is both contrary to the Constitution and is per se incompatible with Article 6.1 of the Convention of the Human Rights. So if there isn't such application, we cannot talk about effective appointment. And consequently, we have to say that the entity appointing or the one who intends to appoint a person to a judge cannot convalidate these solutions. So these were the assumptions that decided about the fact that we distinguished following Professor Tuleya formulates like a constitutional judge, the one who was appointed in accordance with the Constitution, and the act judge who is appointed according to the acts. And these were some assumptions, shortly speaking, that were at the basis of the drafted regulations of the act that were supposed to face the crisis when it comes to the appointment of judges. Of course, at one point, the Venice Commission presented its position on abstract questions from the Minister of Justice, and some of these questions didn't refer to the draft prepared by the Codification Commission. And on the one hand, of course, there is no time just to remind the content of this opinion of the Venice Commission that we scrutinized, but let's stress, following the Venice Commission, that it was said the need to refer to the national constitutional context and that the procedure should be carried out as smoothly as possible. On the other hand, more detailed references were made when it comes to the Venice Commission. That document refers to more detailed solutions which seemed to apply to countries where the problem concerned issues different from those in Poland, such as corruption among judges or their cooperation with authoritative regimes. What is more, the Venice Commission made different starting assumptions than the Codification Commission, namely that judicial appointments had taken place and just that they were only affected by defects. However, on the basis of the Polish Constitution, as already mentioned, it should not be assumed that that we had experienced such effects. The Codification Commission felt that it's necessary to offer alternative solution of this huge problem, taking into account the Venice Commission views. Of course, it wasn't easy, because we realized that there is collision of the values, the rules, on the basis of the Venice Commission. Generally speaking, ladies and gentlemen, the difference between one and the second draft, it was who is to decide on the effects and differentiation of groups of faulty defected judges? Should it be the legislator, and it will be confirmed by an individual official act, or body such as newly elected National Council of Judiciary? And another question is whether to the people to whom this act would refer to, should there be a special appeal procedure regulated in these drafts, for example, to referring to the Supreme Court, or maybe this seeking of the rights of new judges, maybe it could be done on general rules. So like it's done till currently. So if there are the people who contest the status of new judges and they file ordinary suits within the ordinary legal order. The Codification Commission has developed two options for solving the problem. The first one with the statutory solutions, when the legislator refers to the currently issued judgments of the Supreme Court and Supreme Administrative Court and to the Court of Justice in Luxembourg and in Strasbourg. And the one project has this advantage that it fulfills the requirement of the Venice Commission that regards to expeditious procedures to restore the rule of law, to face the problem. What does it mean? What does it mean, an expeditious procedure? So the fastest one, this is 2 years from the time when the act was adopted. So, in an optimistic version, in 2027, we could think about solving the problem. The second option, so the one that the decision will be adopted by the National Council of the Judiciary, the newly appointed one, with the possibility to appeal to the Supreme Court. It means that to this time we should add 2 years at least. So the whole process of restoring the rule of law should take 4 to 5 years, so until 2029, 2030. That currently we have the year 2024. So it's a far-reaching impatience that the situation is difficult. And now we can imagine an even more individualistic and investigative approach to resolving this dispute that evolves into the vetting procedure. But then the period can even take up to 20 years. And this all will take place into the collapse of the Polish judicial system, where you are waiting for the judgments for years. And it is confirmed by the Supreme Control Chamber report. And this is the assessment of the Polish courts, and this is not very optimistic, but I think it's important to read that report. And what's the fear? That the type of restoring the rule of law, that the Polish judicial system can withstand, or maybe it will not withstand it. And I hope that maybe we should adopt an academically best solution, that maybe we will not be able to apply it, and that's there was the proverb that the operation was successful but the patient died, and we wouldn't like to have such an outcome. But what is the game about? The game is about that we can ensure the right to a court to everyone, so that their case is examined, and this is the claim of each person to the rights. So the few thousands who are waiting for the decisions of the Court of Justice of Strasbourg, we must remember about the rights of the new judges who bluntly broke the law just to become these judges. Thank you so much.
Bardzo dziękuję, panie profesorze, za to słowo wprowadzające do dalszych wystąpień.
Thank you very much, Professor, for this introduction, and I am handing over the floor to Professor Banasik, who is going to present the model for repairing the judicial system in Poland. Thank you very much. I'm hoping that everything is working fine, technically speaking. And please, if you could launch the presentation that I've prepared for today. And as I said, first of all, I'm going to concentrate maybe not only on the models with which the rule of law may be recovered in Poland, but I'd like to indicate the broader context mentioned by Professor Markiewicz concerning the legal and cultural conditions that should be taken into account. The starting point of the works is the standard of law for the judicial decisions of European tribunals and courts have expanded the application of that standard also to the process of appointment of judges to hold office. In the light of that standard, during the process, absolutely all of the requirements should be met which have been established by the domestic law, because it is the domestic law that determines whether the court has been established in accordance with the law. Both the convention and the convention uses the word law, meaning an act, but naturally within the internal context of the law of a given state, law should be understood not only as statutory law, but also supra statutory law, meaning, first of all, constitution. So in Poland, not only statutory law, but also the context of the context provided by the constitution. As for the objective of expanding that standard, it is to follow the idea to appoint a candidate among the judges who meets in the best way the criteria for holding the position of judge, which are the criteria which are regulated in the internal laws of the respective member states. And last but not least, the last element of that standard is the possibility to ensure judicial review of the decisions, meaning to refuse to accept a certain candidate for the position of judge. The thus reconstructed standard of law is a reference, first of all, for analysis of the condition that is present in the Polish law legal system right now, and second, it should be taken into account during the works on recovering the rule of law. Let's go to the next slide, please. Before we go to the details, we should remember how, in the light of the Polish law, the process of appointment of judges has been established. As for statutory regulation, the first stage is announcement that there is a free position of a judge. The announcement is made by the competent authority. Second, as a result, a competition is initiated where the National Judicial Council is examining the respective candidacies. The National Justice Board, I mean here the composition of that body established in accordance with Article 177 of the Constitution. This had been addressed today on multiple occasions, so I think there is no need for me to repeat the arguments concerning the accusations against the current norm and the current composition of the National Justice Board. Plus, we should have a judicial supervision by the Supreme Court supervision of the competition, and only after the procedure is conducted in this way, only then is the National Justice Board able to present a motion as defined in Article 179 of the Constitution, on the basis of which the President of the Republic of Poland will appoint a given person to hold the position of judge. And the next slide will show the course of the process of appointing Supreme Court judges in the Chamber of Extraordinary Supervision and Control and Public Affairs to demonstrate the defects. So first of all, the announcement about free judicial positions in this competition was made by the President of the Republic of Poland. But that announcement did not include something that's required by Article 164, counter-signature, which should be provided by the President of the Council of Ministers, because that was an official act of a president that requires a counter-signature of the Prime Minister. Second, these candidacies were examined by the National Justice Board that was developed in a violation of the Constitution, and I'm not going to go into detail here. Second, the National Justice Board in this particular case operated within the composition that was established despite the fact that the constitutional term of members of that board was interrupted. The new act of the 8th of December 2018 violated the four-year term of the previous judges. Plus, the act on the National Justice Board was amended to make it impossible to inspect the outcome of the competition, meaning Article 44 of the Act on the National Justice Board provided that when submitting an appeal to the Supreme Court, a candidate who has been omitted by the National Justice Board, they could not invoke the charges of wrong assessment of whether the candidates were meeting the criteria specified in the law. This was a restriction of the scope of a judicial inspection of the outcome of the competition. Then the provisions of the then statutory law included the institution of the correctness of the act, despite the fact that that resolution was challenged by the other participants in the competition who have not been designated. In this way, the judicial protection was only potential, because even if the appeal had been accepted, the results could not have been challenged, and the candidates could be appointed. What is more, during the nomination process, the law changed, meaning the inspection mechanisms were given to the Chief Administrative Court that was examining the appeals, and during the court procedures, they declared that the resolutions have to be suspended. The appointment of judges to the Chamber of Extraordinary Control was violating the decision issued by the Chief Administrative Court. And finally, under the Act of the 26th of April 2019, what was discontinued under the law was the proceedings suspended before the Chief Administrative Court, which aimed at inspecting the outcome of the competition, on the basis of which the first group of judges was selected to make up the Chamber of Extraordinary Control and Public Affairs. Finally, despite the statutory solution, the Chief Administrative Court revoked the resolutions designating the candidates for judges in this chamber. The next slide, please. The detailed remarks are also significant because these allow to assess the systemic the effectiveness of appointment of judges in the years 2018-2024. Partly, the systemic defective premises are the same as in the original appointment to the Chamber of Extraordinary Control and Public Affairs, meaning examination of candidacies by the authority that was not competent. Second, making it thus impossible to select the candidates who were meeting the highest criteria specified by the statutory law. In particular, because many candidates did not want to participate in the proceedings affected by this defect, then under the Act on the National Justice Board, there is still statutory prohibition of judicial inspection of outcome of a competition if a judge is appointed to the Supreme Court. While in the cases of competitions organized to fulfill judges' positions in other courts, that judicial inspection, and this is of key importance, is exercised by the Supreme Court, the Chamber of Extraordinary Control and Public Affairs, which was developed in gross violation of the law. And as a result of this, it was deemed a body that does not meet the criteria of a court as defined in Article 6 of the European Convention on Human Rights and in the Charter of Fundamental Rights. Now, the Polish system does not meet the standards in the scope in which the standards require that the outcome of the procedures of appointing judges be verified by the court as defined in the Convention, in the Charter of Fundamental Rights, and the Constitution. These deficiencies are glaring and are obvious if we look at their compliance with the non-compliance with the Constitution and EU standards. And so a statement can be made that because of these systemic deficiencies and structural issues, the persons who are appointed judges in accordance with this procedure should not enjoy the guarantees of non-transferability of judges, as this was reserved only for constitutionally defined judges. So this was an introduction, and right now let's characterize the current state of things in the matter concerning the draft work. So according to the information presented by the Ministry of Justice, about 3,250 people have been appointed as judges in a process affected by the systemic flaws that I have just described. Within this group, about 1,200 people had been judges previously, and as a result of the defective nomination process, they took up new positions in another court. So the 1,200 people are active judges who, as a result of a defective model, decided to change their court. The group of about 350 persons, these are candidates who had not been judges, and as a result of this defective procedure, they were appointed judges for the first time in their lives. And the last most numerous group, that's about 1,700 persons who took up the position of a judge for the first time but who were benefiting from the extraordinary circumstances because they were thus following the subjective right to public service, passing the judicial exam and being granted the status of associate judge, or because of the need of the statutory limitation of the deadline for exercising the right to be appointed as a judge. And taking into account this state of things, we should wonder what objectives should be achieved by the statutory law that should recover the rule of law in Poland. Next slide, please. These objectives are as follows. First, in accordance with the recommendations resulting from the European Court of Human Rights in the case of Wałęsa versus Poland, the task of Poland is to eliminate the systemic defects of appointment of judges and thus recovering the operation of courts established in accordance with statutory law and with the Polish constitution. These activities are to recover the social trust in courts as authorities that are completely independent of other bodies. Therefore, we should recover about 1,200 judges to their previous official positions, entrusted to them in accordance with the Constitution and with the law, with the statutory law, in order to eliminate the violation of European standards. This also has to mean that 350 people have to be prevented from issuing judgments as they have been appointed in violation of the law. Then there's going to be the need to repeat competitions for judicial positions which were cast in defective proceedings. Then the outcome, the results of the competitions should undergo judicial supervision. Judicial meaning the court as defined in Article 6 of the European Convention on Human Rights and Article 47 of the Charter of Fundamental Rights. And the rest of the recovery should be the attempt at convalidation of the appointment of about 1,700 judges who are exercising the rightfully acquired subjective right to have access to public service and which should use the legal protection, meaning applying the principle of proportionality and determining weighing the values of legality and the rule of law in juxtaposition with subjective law. The measures that are to recover legality of the solutions have to take into account that the situation of the Polish lawmakers is of unique character. This was addressed also in the previous statements, and this unique character results from the systemic violations and from the scale that I was trying to illustrate just a moment ago. Second, the unique situation results from the fact that the instruments are inadequate, which had been used in the past to eliminate other similar deficiencies in the legal system. This means that the Polish lawmakers have the task of developing a new instrument that would allow to achieve all of those objectives. And in this scope, the Polish lawmakers have some discretion to choose the suitable measures to eliminate that systemic deficiency. This was confirmed also in the previous speeches, but they should also comply with the measurable standards resulting from the European Convention of Human Rights, the Charter of Fundamental Rights, and EU law in general, and take into account the articles of the Polish Constitution. And so there are, in fact, three models that might be used. First, we might assume that recovery of the previous condition and convalidation of the current state will be as a result of a statutory law. Let's call this model ex lege restitution, meaning under the statutory law itself. The second model, which could be used, would be recovery of the previous condition and convalidation of the current state as a result of group decisions by an independent body, as results from the guidelines and suggestions included in the opinion of the Venice Commission. Let's call this a group restitution model. And the third alternative model that could be taken into account would mean verification, individual verification of whether the respective candidates for judges meet the statutory criteria. And the decision could be either made by an independent authority or by a court. And let's call this model an individual evaluation model. Now, what are the advantages and disadvantages of each model? Let's first concentrate on the ex lege restitution model. This one is compliant in full with the Astrakhan standard. In that case, the court of law decided that a defect in appointment of a judge that means that the standard is violated without assessing the judge's individual qualifications. I'm going to go back to this issue later on. In this model, the statutory status of about 1,550 people would change, but with the ex nunc effect for the future, only prospectively, while fully respecting the social rights of the people who, until the passing of that statutory law, have the status of judge as defined in the statutory law. And we would have a statutory convalidation of the appointment of 1,700 judges who are exercising the protection of a correctly acquired right. This solution would allow immediate implementation of the statutory law, elimination of defectiveness of the system as declared in the European judgments, and recovery of a legal condition. The restitution effect would take place immediately. The question remains to what degree that solution is consistent with the Polish legal culture and the Polish normative environment. So the question to that question is yes, because the Polish legislation history knows such general acts which regulated the status of the respective entities and the activities undertaken with their participation. Such solutions were adopted, among others, after the Second World War, where on numerous occasions the lawmakers passed general laws to determine the status of certain activities or certain bodies, but also in the 1980s in the 1980s, yeah, as well as in 2008. But what is significant, such normative acts were also adopted in the 21st century with regard to the people who were judges, and both statutory laws were inspected by the Polish Constitutional Tribunal, positively. The first one was concerning the status of court of the court assistant judges, and the second statutory law was about liquidation of the so-called horizontal promotion institution, which was removed as a result of the decision made by the lawmakers. This solution was considered constitutional in the K7/10 case. If this measure was adopted, about 1,550 competitions would have to be repeated. This would provide conditions for respecting the rights of people who refrained from participating in the defective nominations. Then the judicial inspection of the competitions would have to take place, which would provide the scope for the court to verify the statutory solution, meaning the change in the status of 1,550 judges. And this would provide the possibility of judicial protection to those people. In this optimistic variant, the end of the appointment process could take place within about 2 or 3 years. And this would end the issue of violation of the rule of law in this scope. This would also allow to avoid the paralysis of statutory delegations, because the judges whose status would change if only they were correctly appointed to hold their positions, that would stay in their positions on the basis of the delegations introduced by the statutory law. And as for the group restitution model, let's see the next slide. It is also consistent with the Astrazon standard, but the change of the status of about 1,550 judges would not be under statutory law, but under group decisions made by an independent body. This could be the National Justice Board or the National Justice Board. This idea for making group decisions in the cases of those persons comes from the fact that among the 1,550 people, there are persons for whom other effects are met, such as the change in their workplace, the coming back from retirement, or losing the status of judge as such. So in this model, the judicial inspection of the decisions changing the statuses would have to be exercised to verify correctness and legality of appointment to a suitable group with regard to the personal status of the respective persons. In such a case, the elimination of deficiencies and recovery of a legal solution would take place within an estimated period of up to 2 years. And only after 2 years, the possibility would reappear to recover about 1,550 competition procedures based on the same principles as in the first model suggested today, again with the need to provide judicial inspection. This allows us to estimate that the total process of recovering the rule of law would take place as much as between 4 and 6 years, as mentioned by Professor Markiewicz. And let's look at the last proposed model, that is the individual evaluation model. So far in the public debate, no criteria have been specified for individual evaluation of the respective judges appointed by the National Justice Board after 2018. Well, it would be contradicting the standards developed by the European Court of Human Rights in the Astrazon case. Let me remind you that in that decision, the court stated that violation of the right to the court takes place regardless of whether the judge appointed within an illegal procedure meet or doesn't meet all the qualifications, possess all the qualifications to be a judge. And it does not matter then whether they are capable of being an independent judge, because the European Court of Human Rights stated violation of Article 6 of the Convention, even though the Supreme Court of Iceland had decided before that the judges who had been appointed incorrectly, they still are independent and they rule in a transparent manner. So the adoption of the individual evaluation model would only have to be boiled down to the degree of violation of the law in the procedure of appointing the respective judges, which procedure, as we know, which results from the decisions of the European Court of Human Rights, is affected by the identical deficiency. So there is no space to determine the individual status of the respective judges. Selection of that method would violate of the persons who refrained from the defective procedures in the past and does not guarantee for them the positions that were taken up in the period between 2018 and 2024. This model would have to absorb the efforts of the judiciary to organize about 3,250 individual verification investigations, looking into the possibility of the judges being appointed with defect, whether they could continue holding their positions. It would make it very difficult to predict how much time for eliminating the deficiencies would need. But we may adopt that the period would be not less than 6 years. But it's actually impossible to determine it specifically. And what is important at the time when there is no effect under the statutory law or under the decision of an independent body, the performance of work would result in further violations of Article 6 of the Convention, because until the end of the process of individual verification, there is no removal of the systemic problem. This results in the conclusion that the individual evaluation model does not meet the requirements resulting from the decision of the European Court of Human Rights in the case of Wałęsa versus Poland. And the last accusation against this model is that it would exacerbate the paralysis of the judiciary and the chaos associated with the involvement of judges in the process of auto-verification, no transparency of the process, its prolonged duration, which would result in decreased trust of citizens in courts and in the state, meaning it would not allow in any way to recover the rule of law in the scope of judiciary. Thank you very much. So that's it.
Thank you so much, Professor, for presenting the potential models and current work of the Legislative Commission when it comes to the systemic concept. And now I would like to ask Judge Mr. Jarosław Matras to take the floor. Good afternoon, ladies and gentlemen. Thank you for giving me this opportunity to speak. I would like to ask you that during my presentation, the President, that she will turn on specific slides. Dear ladies and gentlemen, Professor Walasik presented a very complex issue connected with the activity necessary in the future, so to provide for the situation in which the issue connected with the right to a court will be secured for the citizens. the problem, the next problem that appears as the necessary one to solve refers to the facts that are connected with the issuing of the final binding judgment with the judge who was appointed in the effective procedure. So a situation in which we should, and it also results from the pilot judgment, we should repair and give the possibility to challenge such decisions. And this is the perspective of the remedy action. And Professor Walasik prepared 3 models in which it's possible to seek for the systemic solution of the problem and to restore the parties to right of the court in the future. In the model of challenging of a final decision, in an essence, what I will present you, it will work in any of these models. Of course, in the model, in this statutory model and group model, well, of course, there will be other conditions of the starting point or of this point to restore this proceedings, but in our opinion, it should refer to each adopted systemic model. I will present our work in the context of criminal cases. So that's why this is my title, that this is on the basis of criminal cases, because I think that the criminal cases are the one that cause the most social expectations and are the cases that in the public opinion, sorry, we have some kind of echo here, that in the public opinion, they are very interesting cases. And at the same time, they prove to which scope we can examine this and solve the problem connected with the right of law, the rule of law. So here is the main aim of the regulation. 2 aims of the regulation. The first one, as I mentioned before, is the statutory proposal is to ensure the parties who didn't have the right to a court and whose right to a court in understanding of Article 6 of the Convention on the Human Rights or of the Fundamental Charter of Human Rights was infringed, that we have to somehow restore the right to this party. And this is the basic aspect that is present in this solution. The second, also very important one, is the fact that the aim of the regulation is also to stabilize the situation when it comes to the finality of the judgments. So maybe not barrier of the assurance of the law, but about the judgments which were issued, and they were issued by the panel of judges and by a judge who was appointed in a defective procedure. So to fulfill these aims, we will go to the next slide, what is about the requirement to create the regulations. So why do we want to create such a regulation that would satisfy the parties whose right to the court has been validated, and which would lead to the stability of the judgments? And here, the key are the judgments of the international courts, whose status in the context of the Constitution is known to us, and the fact that the obligation of the state is to adapt the national state law to the international standards. It's obvious. In earlier presentations, it was mentioned the pilot judgment of the European Court of Human Rights in the case of Poland, violence against Poland, where such expectations were expressed. Also, a decision was adopted of the Committee of Ministers at the 146th meeting that imposes on the Polish state the necessity to create such regulations in which the rights, the infringed rights, the right to a court should be respected at few different levels. Not only at the level that Professor Walasik talked, but also at the level of the right to a court, about the final binding of the judgments and restoring this right to parties. This period will finish in 2025, in the period during which we should create such regulations. And of course, these are not the judgments of international bodies, because we are aware of the fact that the judgments of international bodies in criminal cases, these, can you show the next slide, are the basis to restore the proceedings. So to challenge the final decisions based on the fact that a judgment of the European Court of Human Rights was made, or the Court of Justice of the EU. So when it comes to the national law, we have a situation in which we need to have an instrument which will adapt the shape of the final judgments and will allow us to restore this and remedy the situation. I want to draw your attention to the fact that in the regulation of the Supreme Court, in the criminal chamber, the right to appeal against the European Court of Human Rights Court is perceived not only from the establishment in which a given person became the challenging party and before Strasbourg Court and won the case, and then that party has a judgment that refers to that person, and it may demand a restoring of the proceedings, but according to the judgment of the Supreme Court, according to the from 26 June 2014 of the Supreme Court, each person who had the same situation, who had the same circumstances, so legal and factual circumstances, can demand the resumption of proceedings. So it's not only limited to specific persons who, with their complaint, went to Strasbourg Court and who won the case there, and the case about the infringement of the rights, but also people in another worse situation. And here I don't need to pretend that the situation in which the defect is in the composition of the court and in the promotion procedure of the judge, it's a special situation which will generate many such cases for resumption, and it causes already many cases that needs to be resumed. There are more and more cases. So we also have to bear this in mind, that the national legislation requires this proper reaction, because the problem of challenging, we will not escape from the problem of challenging these final decisions based on the cases that which Poland lost in Strasbourg Court, connected with the faulty appointment of judges to the Supreme Court. And the next slide, please. And now, the key is the balance, capturing a balance, a specific balance. In the Codification Commission, we talked that we need to find a golden mean. We need to find a specific balance between, on the one hand, the valor of validity of the judgment, the stability of the judgment. Here in the slide, I showed you the judgments of the Court of Justice of the EU, which in its judgments indicate very strong aspect of the need of assurance of the law and the stability of the judgments, which is a significant value for the law, for the state of law in specific countries. And on the other hand, this valor of validity of the judgment must be like this. So in a given situation, it is contrary to the party who was deprived of the right to a court. And the next slide, please. Oh, here, seeking the stability, this golden means, based on criminal cases area, there is such a position expressed that there is the need to resume proceedings due to the infringement of the rights indicated in the Convention on the Protection of Human Rights. It requires a resumption of special proceedings only when there was an infringement of the substantive law of the convention or procedural, but of a basic character. Of course, the judgments of the European Court of Human Rights don't include special forms when it's an imposition to resume the proceedings. Usually it's just the suggestion in this justification of such a judgment. But the national case law of the Supreme Court indicates that you should approach the challenging with special cautiousness. And here we are talking also about procedural challenging when it comes to procedural infringement, because there is the right to the legal order. And this is the very element when the party doesn't have the right to a court, doesn't have the right to a court established by the law. An independent and impartial court. The next slide, please. The conclusion. So what's the conclusion? We decided that there is a special need connected with respecting both the stability of the law and about the importance of the adjudicated case, and also the right to a court whose person was deprived of. And it must create a special mechanism that would create certainty of judgments. And in such a result, the party in the process wouldn't have to take some actions so that it would be examined by the composition in a composition that was not defective, so that it would not fulfill all the essential activities that influenced that its composition would be consistent with the act. So creation such a shape of the basis for the challenging of final judgments has an aim to, first of all, to eliminate the possibility of challenging decisions only as a form of procedural tactics, depending on the content of the rendered judgment. So situations in which the party who has an information about the composition of the court doesn't do anything which the legal measures, procedural measures would allow to lead to the properly appointed composition, but only after the issuance of the judgment that party undertakes specific procedural activities to challenge the composition. And in such case, this is a procedural tactics when you don't use the instruments given to a party, but only later, after the judgment, you try to challenge that judgment, not because the composition was signalized, because there was no information that there was composition, but just simply because the judgment was unfavorable. That's why, in such situation, we give priority to such people and to ensure them the minimal scope of challenging of these procedures, so that the right to challenge the decision was given to a party which is consequential. So it files applications to recuse the judge. It files an application provided for in the procedure that has been from 15th July 2022, special applications for a test. and at the same time uses the appeal measures that are available for that party, regardless of the content of the issued judgment. So the party on its own from the very beginning wanted her case to be adjudicated by the court in not defective composition, and the party was striving for creation of such composition. We want to restore this situation. When you look at the case, examination of a case as a procedural tactic, but we just want to give the right to challenge to these parties which wanted and strived for having the composition in their case, and that composition would be in accordance with the standards. And the next slide, please. And from such category of cases that should be assessed when it comes to the possibility of challenging the final judgment, there were excluded cases in which the judgment were rendered by people to whom the act will not regulate the issue of their systemic position. So here we are talking about court assessors in voivodeship administrative courts, and the judges appointed in a special mode. These cases, of course, will not be able to challenge them. So the proceedings to challenge these judgments will not be initiated, and it will be not possible to do it because for these people, the issue connected with their systemic position will not be regulated in both of these projects. And secondly, we assumed the solution that apart from the category of these cases, we exclude the cases in which the judgment was made in a special cassation mode. So we have the situation that there is again pending decision, the process in which another judgment could have been made. So there are the proceedings pending, and we exclude the cases from this category in which there was the cassation judgment made because they didn't finish criminal proceedings of the person. And from this category, we exclude these cases. And the next slide, please. The basis of challenging the final judgment by us. So, of course, they will be adequate in civil and in administrative procedure. Here, it's just on the basis of criminal cases, but the mechanism is the same in civil cases and in administrative cases. So, if we have a situation in which the case finished in the common court and it finished in a final judgment or in a military court, the basis for the challenging of the final judgment, which became final in the court of the second instance, will be specifically making during the proceedings before the court of first instance a special application for the recusal of a judge, and that application should be based on challenges as far as the correctness of the composition and about the independence and impartiality of the judge, but due to the causes mentioned before during the previous panels. So due to the faulty promotion procedure before the National Council of Judiciary that was shaped by the Act of 2017. So this application should have a systemic character and not connected with specific circumstances, connected with the behavior of a judge. And this is one element. But what is more, what then we require, if a judgment was made, this application was ineffective, there was a judgment made, in the first instance in a validly appointed composition, then we require that the right to challenge such a decision, that the party who filed an application to recuse the judge was consequential. So then it would challenge the decision by validly appointed composition. Without fulfilling these both conditions, it will be impossible to file an application for challenging of performance of the final judgment in the common court. And the next slide, please. When we have a situation, a different situation, when in the first instance, the court, we have a proper composition of the court, to which the party doesn't have any problems with, but as a result of appeal by this party or by another party, then the case is in front of the case of the court of the second instance. And then the party informed and who knows the composition of the court of the second instance knows that this composition is faulty. And in that composition, we have at least one person who was appointed defectively. Then the party should file an application, just the same like in the first situation, to recuse the judge based on the same ground. And it should be done consistently. If the application was not granted, then the person should to use this right to file an application to challenge this judgment should file the cassation unless the system is not provided in cassation, and the party cannot use the cassation. Such segment of judgments is, for example, when common courts, they examine cases, disciplinary cases of different profession. When the parties, then they don't have the right to cassation. Both of these conditions must be fulfilled at the same time. So when the party has the right to cassation, it should challenge that judgment in cassation in criminal cases. And in criminal cases, such cassation will be given to the party regardless of what's the content of the judgment. So, for example, if there is the punishment conditionally suspended, as a rule, the cassation the defendant is not entitled to cassation apart from the situations connected with the composition of the court. And here there is the problem with Article 439, paragraph 1.2 of the Code of Criminal Proceedings. So if the party didn't have the right to cassation, but if not, just an application to recuse the judge from the court of second instance. The next slide, please. And when it comes to the Supreme Court, here, the situation is different due to the fact that the final judgment of the Supreme Court with the defective composition, that you cannot challenge it in the Polish system. So here it's impossible. There is no appeal measurement. So, and as a rule, of course, in criminal proceedings, there are some situations when there is the appeal measure, but as a rule, after each meritorical solution to the cassation, to resumption of the proceedings, there is no appeal. So as a result, we cannot require the party, when there is the composition of the Supreme Court consisting of neo-judges, to require something more than filing in the proper time the application for a recusal of a judge. Then the application has to be based on the same grounds that was mentioned in case of the application in common courts. And then the party obtained the grounds for challenging as the initiative, as in the form of initiative which it has, before the Supreme Court which consists of people that were elected in a defective procedure. As my four speakers mentioned before, they gave you examples of these judgments, both of the Court of Justice and the European Court of Human Rights. So clear situations. None of these people doesn't create court in any chamber, and these judgments cannot be treated as judgments. So here it's just about filing an application for the recusal of judge.
So what should be the formula for the procedural challenging of things? So as for the situation that we have right now, well, the moment we should talk about the moment of the statutory law taking effect, or the ex lege principle to recover the judicial nominations, or as a result of resolutions of the National Justice Board. Here we can see the model where the Justice Board, as the one correctly appointed within the correct composition, is going to adopt resolutions. Then the party has a relatively short 1 month period for submitting the motion for revoking the decision. The motion would have to be submitted by the party itself without an attorney at law. No fee would be required. No need to appoint an attorney at law within such a system would result from the need to provide cohesion of the system, because within the civil procedure before common courts, there is no obligation to appoint an attorney at law in the recovery procedure, while in the criminal procedure, such an obligation does exist. But the assumption is that the element of the motion itself, these are actually simple circumstances. And we're providing a broader scope for the parties to exercise that right, hoping there is going to be quite a lot of motions like that. But because of the mechanism of verifying the possibilities, there is no obligation. We believe that there should not be the obligation to appoint an attorney at law. This would provide problems with access to attorneys at law, or granting within a suitable procedure the appointment of an attorney at law to each of those persons within a situation where, of which we're confident, the premises of the motion for challenging are relatively simple to be determined by every party to the proceedings and relatively easy to be demonstrated, and verification of those premises is also relatively simple. So the inspection would not be too difficult for the courts. If the deadline is missed, if the party demonstrates that it was not through their fault, the party will be able to ask for a recovery of the deadline. The next slide, please. So, what court should examine? So, in the criminal cases, that would be the court with jurisdiction for recovering procedures. So, this is a typical resumption procedure, a typical resumption court. But the regulations would also be proceeded in the resumption mode. So also the Supreme Court, which would be the active court within this procedure, it would rule on the resumption the resumption motions, which ended up in the Court of Appeal. The principles for examining the motion? Well, a judge who was appointed in a defective procedure may not be within a composition like that. So it will be the same court as in the resumption procedure, and we would meet the principles of the resumption procedures. So if let's say the defendant wants their case to be resumed, their situation would not be deteriorated as a result of a decision adopted. Another obstacle that we're eliminating the possibility to challenge the judgment for other persons. So if there are 3 convicted persons, but the procedure is initiated only by one of them, then there will apply the principle, Article 435, meaning the challenge only applies to the party that wants to use it. So it wouldn't be applied to the person who does not initiate it. Another element of the procedure, statutory requirements with regard to the challenge have to regulate and ensure stability of the situation for the future. And we have to make sure that the decisions are valid. So on the one hand, the deadline is short, with a broad access for the parties, without the need to appoint an attorney at law, with procedural guarantees that their situation would not deteriorate, but also for the future in the criminal procedural law and in the civil administrative law, it would not be possible to challenge those proceedings on the basis of deficient appointments. So the cases where in 1 or 2 or 3 years' time someone would want to challenge such proceedings would be excluded, so that we have stability of decisions and impossibility to challenge a procedure which has been started already. Next slide. As for the type of decisions, well, that's quite simple. If in the second instance the composition is erroneous, is defective, then the court will revoke the court and will refer the case to the court with jurisdiction in the second instance. And the situation would apply, which is well known in the criminal proceedings, meaning there is no need to refer the case if there are procedural obstacles, such as the act taking place too long time ago, and if the composition of the court was wrong in the first instance, then the final and valid of the judgment of the first instance will be revoked, and the case is referred back to the court of the first instance, again excluding the situations where there is a procedural obstacle. Then again it is going to be discontinued. The next slide now. As for the Supreme Court, the judgment of the Supreme Court and is referred to the Supreme Court for re-examination within the non-defective composition. Next slide, please. Was that the last one? Yes. So thank you very much. So naturally, this refers to the penal procedure, but the method or model is the same in the respective procedures. and separate regulations for resumption of decisions, but this is not what have not addressed this in my presentation, but in the Chamber of Extraordinary Control and Public Affairs, this is going to be addressed. Thank you very much. From November 2024, C326/23, where the Court of Justice of the European Union has the same approach to this issue, stating that the main essence of the problem is denomination issues. And I'd like to emphasize what Professor Markiewicz said, meaning that we're looking for an effective solution while respecting all the rights, including constitutional rights and EU standards. We have suggested three models: the ex lege restitution, group restitution, and individual evaluation model. And according to us, only the first one meets the premises of effectiveness. And in the last panel, we have adopted the principle that stability of decisions is a principle, a rule, and the exceptions with regard to the possibility to challenge, they have to meet the European standards, including the OECD opinion, which has been adopted recently. Right now, I'd like to order a break of about 4 minutes, and 3 minutes maybe, and at 1 p.m., the
Proszę Państwa, witam ponownie na trzeciej, ostatniej części
So
naszego...
we're starting the last third part of our experts panel right now. We'll pay attention to deficiencies in the nomination procedures, meaning and we're going to present our expectations from the procedures to make them correct and to contribute to an improvement in trust in the justice system and Polish judges and European judges. Thus, this challenge, this is the challenge that is faced by our speakers, and with the special guest, Kees Sterk, the chair of European Administration of Justice at the Maastricht University, a friend, I could say, of Polish judges for quite a long time, since the very beginning of the constitutional crisis. That's why we're very happy that he is with us. We also have Professor Katarzyna Gajda-Roszczynialska, who is going to present this issue from the point of view of the Commission for Codification, and the Deputy Rector, Professor Tomasz Pietrzykowski, who is going to present the position based on values that have to be respected and respected well. I'm very interested in what all of the speakers are going to say, and right now I'd like to ask Professor Sterk to take the floor.
Okay. Well, thank you very much, Mr. President, distinguished colleagues, ladies and gentlemen. Thank you for the invitation to speak here on this subject, which is not only a subject that is of importance for Poland, but for, I would say, the European Union and the European Council, for all of Europe, especially in times where the rule of law is under threat, and not only in Europe. So I will focus in my speech on a specific topic of the new judges, that is the methodology of establishing the meaning of legal text in European law in exceptional circumstances. So what will I do? I'll start with a small tour around Warsaw, and then I will try to explain why this small stroll is of importance to our topic. And then I go to the traditional methodology in Europe of establishing the meaning of legal text, and of course, the same subject in exceptional circumstances. I will touch upon the Venice Commission opinion of neo-judges, and I finish with, of course, a message, be it a humble message to the Commission, of course, because the Polish Commission and government and Parliament are in charge here. So first, I start with my small tour. I start from the Supreme Court. If you leave the Supreme Court through the main entrance, you go to the street, and then you go to the right, and then you have an arch overlapping the street. You cross the street, and then you find a pillar there. And on this pillar, there is a Latin text. There's also a Polish text, but I will not torture you with my Polish pronunciation, and I will just mention it in Latin, and then I will translate it in English. It says, and it's a text from the lawyer Celsus, scire leges non hoc est verba, eorum tenire, sed vim ac potestatem. And it means to establish the meaning of legal texts, one must not only consider its wording, but also its sense and purpose. I would say a very common way of methodology of overall in Europe. But there are also, in the digest, there are also texts about exceptional circumstances.
There is one of Paul. I don't know whether it's on the pillars of the Supreme Court. I have to look for that, but I come back for it sometime to see. But it is, and I start with the English translation, it is like this. He who solely abides by the wording of legal texts contrary to its sense and purpose evades the law and thus commits fraud, they say, fraus in Latin. And in my own words, he who does that is not establishing the true meaning of the text. So this is a discussion of 1400 years ago, but a discussion which educated all the legal systems in Europe. And why is it still important to our subject? Because if you look at European law, and it is said by many of the law professors in this seminar, 300 judges, called neo-judges, are not judges according to European law, because their appointment was defective. But on the other hand, we see a Polish situation where these neo-judges are acting as judges. Their judgments are rendered, and it is not, as I said, it is not like in Iceland. 4 judges, it is 3,000 judges and more. So I would say, indeed, exceptional circumstances in Poland, and not just business as usual. So if you look at the traditional approach of European law to, I would say, defects in judges, it is usually not about defective appointments, at least not on this scale, but it is on defective behavior. And the traditional approach is an individual procedure on the basis of strict criteria for discharging judges before a body independent from the executive. But the purpose is of this traditional approach to protect duly appointed judges against undue influence from the parliament and the government, and of course maintaining high standards of behavior for judges. And these purposes are not the purposes of restoring the rule of law as to these neo-judges in Poland. I come to the Venice Commission opinion on neo-judges. We all know more or less what is in it, and I would say that the purpose of restoring the rule of law or the independence of the judiciary as to the neo-judges cannot be reached by following the wording of the standards concerning defective judges. I think that is what the Venice Commission is saying. And there are some reasons for that. And these reasons have been mentioned by previous contributors to this seminar. The first, of course, is that it is a systemic undermining of the independence of the judiciary. As I said, it is not 4 judges like in Iceland, it is 3,000 and more. And this was established in the Valenza case. And there is another reason. According to European law, the neo-judges should never have become national Polish judges because their initial appointment is defective. That's a different situation from the cases that are pending, or have been pending, before courts as to the behavior of judges. And the fourth factor here is the sheer number of neo-judges, 3,000 and more. And if you would follow the European law standards to defective judges, to its grammar, to its wordings, just to its wordings, the result would be that for too many years, of ongoing undermining of the rule of law would continue and continue and continue. So in other words, just abiding to the wordings of the European law standards on defective or corrupt judges, on judicial independence, is obviously contrary to the sense and purpose of restoring the rule of law and the independence of the judiciary in Poland. This methodology, and I'm paraphrasing Paul, as I mentioned earlier, would evade the law, would not apply the law. And this was already mentioned, as I said, 14 centuries ago. So this is not a new idea. It is in our legal systems for more than 1400 years. So don't say this is totally new and it is whatever. It is not. So I come to my message. In my opinion, the Venice Commission followed the methodology of Roman law, which was received in some form or other all over Europe, also in Poland. Just look at the Supreme Court building in Warsaw. That is one. The second is the Venice Commission gives room to maneuver, a discretion in European law for the Polish government and parliament. And this is a discretion in European law. It is not the same as the discretion a national system has in translating, in implementing European law into national system. Those discretions I would like to distinguish. This is the first discretion. So the European law itself gives room to maneuver, gives this discretion. And this discretion is quite large, I would say. Far larger than I sometimes hear from Polish contributors to the discussion. And of course, Polish national law, we all know it because it's just European law, including the constitution, has to be interpreted in accordance with European law. And also the discretion European law gives to the Polish government and to the Polish parliament. So, European law gives a large room, large discretion to restore the independence of the judiciary in Poland as to the neo-judges because of the exceptional circumstances in which Poland is at the moment. And if I listen to the options of the Commission, I would say probably all three options would be within the discretion of European law. But, of course, there is also the time issue here. So, and that is, of course, up to the Commission and to the Polish Parliament and to the Polish thing. But if you want to restore the independence of the judiciary within, I would say, a reasonable time, it is up for the Commission, for the codification of the system of judiciary and public prosecutor's office to show courage, to be willing to restore it in this reasonable short time. And this is my end of my short speech. Thank you very much.
Bardzo dziękuję, panie
Thank
profesorze.
you so much, Professor, for this inspiring speech indicating two things. First of all, huge discretionary area to restore the rule of law. And secondly, to remember that this avoiding following the law can take place through the reference to literal meaning of some rules, and omission in activity also can result in the fact that we will not follow the standards of the law. And what's the response of the Codification Commission of this very detailed assumptions of the drafts that are currently made when it comes to the appointment procedure? We will shortly get to know from the speech of Professor Katarzyna Gajda-Roszczynialska. Please, the floor is yours.
Thank you very much.
Dziękuję.
I would like to start with one general remark. We all know that the right to a court at the European level depends on the court being independent and impartial. And there is a close relationship between the nomination system and the right to a court. I would like to say a few words how we want to go back on the tracks as a Poland and how we would like to restore the rule of law in our projects. When we look at the recent case law of courts in Luxembourg and in Strasbourg, there is no doubt that the appointment of a judge in a valid procedure in accordance with European standard is one of the necessary conditions for realization of the right to a court. And we also must underline what Professor Walasik already did, that in years 2018-2023, many legislative changes relating to appointment and promotion procedures were introduced. Consequently, these procedures were carried out with the manifest and flagrant violation of judicial independence and of course independence of judges, which in many cases led to the situation when Polish courts were not courts established by the law. The systemic and also blatant nature of the violation of the rule of law was primarily related to the participation in the nomination procedures, the improperly formed National Council of the Judiciary, and this issue is already regulated by a separate bill that is under procedure. But in many cases, there were appointments that were not based on merit, which is a violation of European standards. For example, Standard 25 of European Law Institute, Mod Scopus European Standards for Judicial Independence, or violation of the requirements of fair and transparent procedures, for example, by depriving candidates of opportunity to appeal against the resolution of National Council of Judiciary, or by handling in presidential nominations when the nomination procedures were suspended by administrative courts. And it is a violation of Standard 26 of also European Law Institute, Mod Scopus European Standards for Judicial Independence. At the national level, we got also the changes according the bodies responsible for the procedures, the bodies of the courts that have been participated in the selection process and screening candidates were changed. Instead of assemblies of judges, new judges colleagues were established. New judges colleagues after 2018 consisted exclusively of new courts president, mostly so-called fax president. And they were appointed by the Minister of Justice without any participation of judicial community or the civil society. The requirement of accountability and fair reflection of society was no way realized during years 2018 and between 2018 and 2023 in nomination procedures. Moreover, standards have been significantly lowered. For example, the possibility for lawyers with dual citizenship to take part in competitions was eliminated during one of the amendments. All this make it necessary to resume the selection process and conduct them in such a way as to restore the Polish legal order, to restore the right to the court, ensure stability of legal order and also stability of judgments. The projects also try to restore the public confidence in courts and, of course, restore the rule of law. The drafts introduces new regulations for selection process in common courts, in military courts, in administrative courts, and in the Supreme Court. When we go back to the models described by Professor Walasik, all these drafts can be implemented in any of these models. I would like to also highlight that the projects takes into account European standards. We also take into account the rule of law checklist from 2016. Our main idea was how to allow everyone to participate in the renewed competitions so that only the best judges are selected, but above all, right to a court established by the law can be realized. So, how does it look like? At the outset, it should be pointed out that the appropriate model for the Polish system is a system based on the National Council of Judiciary and Public Prosecution. Of course, there is a possibility to admission of representatives of other legal professions like barristers, attorneys, or notaries, and the model is preserved in principle. What is the most important thing? The new regulations for selections improve the merit criteria for selection. For us, it is clear that the judicial selection, appointments, professional evaluation, and promotion must be based only on merit. The merit must be defined by adequate, objective, and published criteria having regard to high standards of professional qualification, integrity, ability, efficiency, and objective needs of the court. And the amendments that we are proposing in the Base Act, the law on the common court system, clarifying the substantive criteria for both judges, prosecutors, advocates, attorneys, or notaries, and this criteria supposed to ensure this. What we also have done, we have modernized the criteria for law professors and brought it into line with the actual Act of the Higher Education. We also introduced changes in the professional evaluation. We also introduced in the project changes in the procedure itself to ensure that the system for selecting judicial candidates is independent, fair, open, and transparent. We provide that appeal to the court is provided against the decision at the preliminary stage as to membership in particular group in the second version. And of course, and the decision of National Council of Judiciary. Also, the candidates have a right, what I would like to underline, that candidates have a right of review of the lawfulness and judicial selection before an independent and impartial court. A recent decision, what is also important, that every decision is a recent one, provides as a record sufficient to examine unsuccessful candidates' challenge to the decision legality. In our regulations, also transparency has been strengthened. According to the new regulations, the president of the competent court to which the candidates' documents have been submitted shall make public the list of the candidates for the vacant judicial post with the content of the orders by publishing the information in the public information bulletin. Also, we are introducing changes with regard to the selection bodies for appointment and promotion. First of all, the draft assumes competition before a properly formed and new National Council of Judiciary. Also, in common courts, but in administrative courts and before the Supreme Court, we provide a proper democratic representation of judges. For example, in common courts, a new democratic body, the Assembly of Representatives of Judges from Appellate Area, which is a representative body of all judges in this area, is taking part in the nomination process in place of politicized body, judicial colleagues. At the same time, in our draft laws, the composition of judges' colleagues will be reshaped. We are also thinking how to implement the requirement of fair reflection of society. At first, I would like to underline that the project removes the impossibility for people with dual citizenship to participate in selection process. So the new regulation will also introduce instruments to monitor diversity and guarantee gender equality where it will be possible. Also, with special attention, we regulate the situation of new judges, I mean the assessors. In project we put guarantees for participation in selection process for assistants and referendaries, and we want to restore these guarantees. That's the way that we look into this requirement of a reflection of society. And what I would like to say at the end as a conclusion, from our point of view, the resumption of selection appointments, professional evaluation and promotion of judges will not only guarantee the restoration of courts established by the law in Polish legal system. At first, we would like to rebuild and restore the rule of law, but what is the most important? We would like to prepare the regulations which will allow to selection of best of the judges. And always we must remember that courts are not foreseen for courts itself or for judges. The courts are for citizens. Thank you for your attention.
Dziękuję bardzo, pani profesor.
Thank you so much, Professor, Lady Professor. I can see from your presentation that the Commission not only faces the problem of regulation of what was bad, but also we have to face with challenge to create special procedures that will not only be restoring of what was before, but what will allow us for obvious fulfillment of standards, which are, of course, provided by Constitution and international law and international standards. And here, it's not about fulfilling them to minimum extent, but in such a way that it was an incentive to regain the trust of people to courts and also trust to the state. Now I would like to ask Mr. Rector, Professor Tomasz Pietrzykowski, to present the challenges, the constitutional challenges when it comes to the processes of nomination in the context of the fulfillment of the Constitution.
Good afternoon again. Now I appear in my second hat, the one of the researcher, and I must confess that I feel more comfortable and natural in this one compared to the one of the administrator, but to the point, because we are behind the schedule. So how to solve the problem of so-called neo-judges? What goals, risks, and considerations should predominate in looking for the right solution? Obviously, I'm not in a position, and I don't even aspire to offer comprehensive and definitive answers to these questions. That would be a conceit exceeding even average academic standards. So my aim is much humbler, is just to contribute to that discussion with some observations of an independent legal scholar, not involved personally in any decision-making bodies or committees or processes, but rather trying to follow as closely as possible the events and the debates from the very beginning of the constitutional crisis in Poland almost a decade ago. But I must begin with some preliminary caveats. Namely, my perspective on this issue is somewhat specific compared to the previous speakers. I don't specialize in any particular branch of legal doctrine. My area is legal theory and philosophy of law, and therefore my approach is much less oriented toward detailed analysis of any particular legal provisions or judgments, neither those violated in recent years, nor those that are being devised right now to create a reasonable way out of the problem. What I'm interested in much more are the relationships between legal regulations and their axiological value underpinnings on the one hand, and the short and long-term social empirical consequences on the other. So 5 brief theses that I'm going to offer today reflect just that point of view. And I hope they will be somehow complementary to what has been already said earlier today by the eminent speakers that spoke throughout the day. Due to obvious time constraints, I will limit myself to only short comments on each of these theses without developing full detailed argument in support of any of them. But in most cases, I believe such arguments are rather easy to reproduce, even if typically remain far from uncontroversial. So the first thesis I'd like to put forward today could be stated as follows. Seeking solution to the problem of neo-judges should be conceived as seeking the best means to safeguard relevant intrinsic constitutional values. These values are primarily the reinforcement of the rule of law, of legality, judicial independence, and impartiality of the judiciary. I want to emphasize that this apparently obvious claim has one important implication. It entails that specific legal protections of judicial position, including the irremovability of judges, are not intrinsic values in themselves. They are rather instruments aiming at realizing the ultimate constitutional goods. That's why they mustn't be construed out of their wider axiological context, and their scope and strength need to be optimally adjusted to attain and sustain those relevant supreme constitutional values. And I would evaluate potential solutions to the neo-judges issue mostly from this vantage point. And now I'm moving to the second thesis. It is inspired by the observation which the recent Polish crisis has quite clearly demonstrated, namely how important the personal qualities of persons holding judicial positions are for the viability of the constitutional order. In fact, Poland has been saved from quick and seamless descendance into an illiberal and probably undemocratic regime, largely due to the integrity and solidarity of the large number of Polish judges, and to a lesser extent, other legal professionals too. So my second thesis is that democracy and the rule of law in Poland survived to a large extent due to the personal attitudes prevailing among the judiciary. By the way, I find this phenomenon almost unprecedented. Lawyers typically rather easily and obediently adapt to political changes of that kind, thus reflecting upon conditions for preserving judicial independence and impartiality. We should certainly bear in mind not only institutional arrangements, but also the mindset and morale of the persons making up the justice system. We lawyers often tend to neglect or at least downplay such factors, believing in the decisive role of legal guarantees and the power of formal constructions. I conceive it as a mistake, even if the opposite view would be a mistake too. We should acknowledge the significance of both dimensions. Proper rules are an indispensable background condition for having an independent and politically impartial judiciary, no doubt about it. But paradoxically enough, it is easier to produce such rules in the legal books than to take effective care to maintain the judiciary composed only or even mostly of people actually deserving such guarantees. We are not used to thinking in these terms, let alone in terms of how our legal decisions actually shape people's attitudes and commitments beyond the immediate behavioral effects law manages to trigger or doesn't manage to trigger more often than not. It is largely neglected, not only in daily legal considerations, but also in scholarly literature where it occupies a relatively rarely visited borderland between legal, social, and psychological inquiries. It brings me to my third thesis, which I believe is one of the crucial lessons from the Polish crisis. Personal attitudes of people holding judicial positions should be the central concern in efforts to make the justice system resilient against future attempts on its independence and impartiality. Institutional guarantees are important and must be further improved, but they may be ineffective or even counter-effective if the attitudes prevailing among the judiciary are not defiant enough to object to making the justice system a tool for politically partisan goals. One may argue that, in fact, the stronger the institutional protections for judicial independence are, the more critical the internalized constitutional commitments of the persons occupying judicial positions. Otherwise, such protections, instead of serving the ultimate legal values, may in fact contribute to their further distortion. And here I would like also to indulge myself into one spontaneous comment to Professor Sterk's presentation, because to me it is not only the question of numbers and time factors, even not mainly the question of time and the number of neo-judges, it is the fact that most of them, except the young graduates who had no choice, in fact, deliberately decided to take part in those unconstitutional procedures, being aware why and for what reasons they have been actually established. So this is certainly something beyond the question of practical effectiveness and time needed to solve that issue. So in view of that, my fourth thesis would be the following. Validating neo-judges' nominations could have detrimental effects on the morale of the judiciary, making it less capable of cultivating virtues necessary to defy potential future political assaults. Law not only directly regulates conduct, but also has important expressive and symbolic functions. Legal decisions mark, so to say, behaviors are socially laudable, deplorable, or tolerable. The reaction of the democratic lawmakers to attitudes prioritizing personal benefits over loyalty to the Constitution may send, even inadvertently, a strong and long-lasting message. It may easily become a clue for many if they come to face similar dilemmas again. And it would be utterly naive to assume that we don't need to take the perspective of such history repeating itself seriously. I'm sure we all well remember the famous ending of Albert Camus' The Plague, where Dr. Rieu contemplates that despite the public celebrations of the victory over the plague, nothing is actually over. The virus, as he well realizes, never dies, just hides somewhere to sooner or later attack again. So it is of pivotal importance that individuals in the judiciary and outside of it perceive that their personal choices are socially recognized as making a serious difference and deserving adequately serious repercussions. My final thesis will be, therefore, a refutation of the popular argument often raised in the context of neo-judges' situation. I will call it an argument from precedent. It says that we should be careful not to do anything that could set a wrong precedent for future governments and parliamentary majorities, since such a precedent may encourage them and pave their way to do the same over and over again. So my fifth thesis claims that this argument is deeply flawed. The right response to neo-judges' questions should include at least depriving them of the benefits achieved by their disregard or even support for the attempt of political capture of the justice system. Such a reaction cannot set a dangerous precedent for any future government genuinely respecting constitutional values. At the same time, we shouldn't delude ourselves into thinking that a government not respecting such values will need any precedents of this kind whatsoever, or that it will let itself remain constrained by good, in inverted commas, precedents set by previous democratic majorities. How far it will be able to go in the political subordination of institutions, including judicial ones, will depend much more on the integrity and the mindset of individuals that those institutions will then consist of. So reinforcing the right attitudes and minimizing the influence of the wrong ones is what matters most for making our institutions less fragile in case of the next threats of illiberal populism. In consequence, contrary to the argument from precedent, what we really need is that the democratic community sends an unequivocal message that it takes the constitutional values that were so recently at stake not less seriously than the judges who defended them. Such a clear message, if anything, can set a precedent that may matter for enhancing the judiciary's resilience. It is by no means certain that it will be of sufficient help anyway, but it is rather certain that without it, the future chances to effectively defend the independence and political neutrality of the justice system will be rather dim. Thank you very much.
Bardzo dziękuję, panie profesorze, za to.
Thank you very much, Professor, for this interesting speech.
bardzo dobre podsumowanie całej konferencji, ponieważ
And I think this is quite a good summary of the entire conference, because beyond any doubt, of which we often forget recently, that we're not meeting here to resolve some kind of task, a case study that we are appointed with during some classes at university. No. Behind us, the difficult 8 years, almost a decade, of gross violation of the rule of law, of the constitution, of something that is called constitutional crisis in Poland, where strength was above the law, or power was above the law. The question now is not only how to resolve the crisis, but also how to avoid it in the future. And so we have to be victorious in this struggle. This gigantic challenge may not result only in just shrugging and saying, all right, the tools that we saw in Europe are ineffective, and so maybe we should just do nothing and try to convince ourselves that the situation is just very poor, and that's it. No, the obligation of every single one of us is to find the tools to bring Poland out of the constitutional crisis and to avoid such situations in the future, and to draw the lessons that the Polish state, as a member state of the EU, will always react to such a situation. So that no one benefits from the absence of the rule of law that they have caused. That would be a real failure of the state of law. And certainly we have to avoid such situations in the future. I'd like to thank you very much, ladies and gentlemen, right now, for participating in this discussion, in this expert panel. As I announced at the very beginning, we are now between, let's say, tasks, not only ending one year and starting another, but also within the works of the Commission, some things are being developed, and I'm hoping that over the next several weeks we'll be able to present our draft with justification, because there is a point in presenting drafts only if such a justification is also presented, because this matter is very complex, very broad. There is no one single solution for everything, and I'm hoping that in several weeks we're going to organize the next event, the second half, let's say, so that we find out whether we have managed to follow the European standards, and so that we perform such an evaluation assessment. So again, thank you very much, ladies and gentlemen. We have managed to not to take too much time, only 30 minutes after we've run out of time. So I think this is still relatively acceptable. So again, thank you very much, and I wish you to have a peaceful Christmas, and I'm hoping we're going to live in a